Good morning.
Good morning, good afternoon, good evening, everyone. I'm trying to see whether everybody's accounted for. Dr. Hap and Professor Aubert for the claimants. Is everyone in?
Everyone is here.
Yep. And then Dr. Conrad for the respondent. Everyone is in?
All present and accounted for.
Thank you.
Awake and bright.
Okay, good. Then we have first a few matters. Before we start with the closing submissions, there are a few matters which I would like to resolve procedurally. So you got this morning, somewhat late, additional questions on the models. We believe that you and your experts can answer that with yes or no easily, but we simply want to be sure that we have understood it correctly. So if you can check it with your expert and could answer today, would be much appreciated. Otherwise, please answer them in your post-hearing submissions. What we would like to do additionally is, because these questions were in late, and we understand also that experts on both sides may have to be woken up for this purpose, because in the United States, that we have, after our closing submissions, we have a small extra round for answering the model questions, if I may put it that way, so that everyone has the possibility to consult his or her experts and then to answer it today. It would be much appreciated. So rather than delaying as the claimants have proposed for 2 hours, I think that is not a good thing to do for answering those questions. But rather than have them at a separate little round at the after the closing submissions for today.
Mr. Chairman, is that to follow immediately after the closings, or what is the?
Oh yeah, we take first. You have between the two closings, you have 15 minutes break. Then you have a 30-minute break, because that's as usual, and then we have this this little exchange.
Okay, understood.
Yep. Is that acceptable to the claimants?
Yes.
Yeah. To the respondent?
I believe we won't be ready by that, so we will have to defer it for the post-hearing submissions.
All right. Okay. Well, so be it. Then we have the other thing is still the post-hearing submissions themselves. First of all, the transcript. We have the transcript as in the PH 30. That is some 30 days, and including the Christmas piece, as it is referred to. So that brings us to 15 January for the transcript, and nothing beyond that, because there we really stop with the revising the transcript. Normally that's all done as work done overnight, but okay, in this case this takes somewhat longer. Then we have 15 days for the tribunal to resolve any outstanding issues around the transcript. That brings us to the 1st of February. The tribunal will then expect the post-hearing submissions on the 15th of February, simultaneous filing, and on the 1st of March, rebuttal post-hearing submissions, also simultaneously.
I have to say, for respondent, that's not possible, because we have 3 memorials in investment cases before Christmas, and exactly in that period. For example, one deadline is on 23 December. We have shuffled around everything else we had on our plate in the, and I don't want to boast, but not insignificant number of cases. And it's simply not doable. Even if I let my associates work over Christmas, which after this year probably would expose me to sanctions in various ways. We have tried to make it as fast as possible, so we would be ready to file on 8 April.
What do you mean by 8 April? What to file?
Post-hearing submissions.
Professor Aubert or Dr. Hap?
I think I'll leave the floor to Dr. Hap.
Yeah, thank you, Professor Aubert. Mr. President, the time limits as such, I think, are fine with us. We would manage to do that. However, claimants believe that there's no need for reply post-hearing submissions. This has been a very simple question which you asked. We had very clear evidence. And if we start with reply submissions, then we'll end up with longer time periods and you don't know what you get unless you impose page limits. We would be fine with page limits. That would ensure that all the efforts of the parties are concentrated on the really important aspects. I'm sure you don't want to receive another 400 page of post-hearing submissions by either party. So we would be fine with that. We prefer one round and the page limitation.
Wait a moment, Dr. Conrad. And as far as the periods of time are concerned, you're Dr.
The
Conrad?
Periods of time are for us no problem. We can submit if the final transcripts exist on 1st of February. We can submit post-hearing submissions on 15th of February.
Okay, let me first address your point about the reply submissions. Experience has borne out that if you have a simultaneous filing, then after the filing is received, the other side says, well, wait a moment, there's a submission of a hearing I have not attended to, and I seek leave to respond to it. So that to resolve that type of question about raising the leave takes more time than having a reply post-hearing submission. That's the reason why we have already inserted, in light of the simultaneous filings, that we have also simultaneous rebuttal filings in 14 days within a short period of time. So that is one thing. As far as the limitation of the content is concerned, we have already indicated that the content is limited to an index, how it ties into your case, plus an additional points. That is basically what it is. The tribunal does not want to straitjacket the parties further, or actually at all in this with regard to post-hearing submissions. So that resolves the point, these points about the contents and the number of exchanges. The point what really is outstanding is now the period of time within which they have been submitted. The tribunal really would like to finish this case now after so much a long time, and doesn't want to have any further delays.
We don't either. We just can't any earlier than 18 April. However, what I can say is that if no new evidence is submitted by Vattenfall, we don't necessarily need reply briefs. It just depends. And you have yourself granted Vattenfall leave to ask to submit no evidence with regard to the portfolio effect. If that happens, we need replies. If it doesn't, then maybe not.
Dr. Happ, can you give the undertaking that you will have no new evidence?
Not at this moment. I need to go back to the client, but I think the proposal by respondent that we only have reply round of post-hearing briefs if there's new evidence is as such a sound one, as long as we stay within the time limit suggested by the tribunal. That would make, without new evidence, one round and then stop. And if we ask for leave to submit new evidence, then there can be a reply round, limited to the new evidence.
Let me be clear, the post-hearing submissions are not intended to submit new evidence.
That is understood, Mr. President. I referred particularly to the topic of the portfolio effect, where the tribunal has invited us to consider at least doing that. I don't think, I currently cannot say whether this will be done or not. That is a matter for deliberation between me and my colleagues and the client. But if we have a rule that says post-hearing submissions, one round, simultaneous filing, and if claimants were to ask for request leave to submit new evidence on that topic, then there can be a reply post-hearing submission round on that topic only.
Is that acceptable to the respondent?
Provided, well, if that is so, yes, but for us, the important point is 8 April.
That's the other issue, another matter. But first of all, that's what's the content and what are the number of rounds. So we have only one round, unless there's new evidence, then we have 2 rounds. Simultaneous filing. That's one thing. So now let's go to the period of time. So the tribunal was of the opinion that we could have the 1st of March, the reply submissions, if any. and the 15th of February would be the post-hearing submissions themselves. And the respondent is proposing almost 2 months later, is it correctly?
A mere 8 weeks after the finalization of transcripts. And I caution again, I had a conversation with Mr. Hub last night, and he revealed that they even had a translator watching and listening in parallel to check that. We don't. We have 3 associates who are also working on the other cases. There's no way we can possibly do that.
Dr. Kwaad, let's be clear. Is it your client who has a problem with a number of cases, or is it your firm that has a problem with a number of cases?
Both of us, because as you know, also under the rules of the client, in order to do the get instructions on the filing and on the drafts, we have to adhere to certain guidelines. And it is neither possible for my client nor for my team. And as you remember, this case is now in its 9th year. I can't get somebody from another office, even though those are excellent US litigators, to write about the portfolio effect in a case where the documents fill several rooms. It has to be the people who work on the case.
Dr. Hub?
Mr. President, just some few remarks. Firstly, I haven't revealed that there's a Czech interpreter. The Czech interpreter was on the list of defendants from the beginnings. Second, the Czech interpreter had only few remarks, so checking translation should be no problem. Thirdly, I find what my learned colleague says about caseload and what her client, the Federal Republic of Germany, can or cannot do, to be frank, hardly credible. We are not talking about a backwater state. We're talking about one of the richest nations on earth, where 5 ministries are involved in this arbitration, which has been able to procure even a translation of the Constitutional Court decision within short time without any request by the tribunal. That they should not be able to review the transcript, not the post-hearing submissions, in that time is hardly believable. And since the tribunal asked essentially for an index, that this cannot be done in 2 weeks' time with the limited relevant evidence we had this week. Well, I stay with our position. We agree to the tribunal's proposal.
Dr. Kwaad, you have the last words on this one, and then the tribunal will take it under advisement and will give the ruling later.
No, I think I need to correct a misstatement by Mr. Hub. We've been asked questions by this tribunal, and we intend to answer them to be helpful and facilitate the writing of this award, including making it easier and faster for this tribunal to write the award. You have not, he just stipulated you have asked for an index. No, you haven't. You have asked us twice questions and said we should also answer them in the post-hearing submission. Thank you very much.
Right, so we take it under advisement and we'll issue a ruling later on this point. Are there any other procedural matters outstanding? Dr. Hub, for the claimants?
No, thank you, Mr. President. Or no?
I see how in unison also the whole aware is answering. Right. Okay, this is the claimants. Then Dr. Conrad, for the respondent, any other procedural matters outstanding?
There's one which I think you should come back to at the end of the closings, and that is transparency. We've now had a week full of hearings, and I can see from Mr. Hub's conduct that he wants merely 2 weeks of post-hearing submissions, that he probably thinks he's confident in the performance of their 14-people team on this case. And therefore, we believe we should follow the example of 2016. And I would hope that Vattenfall would agree with me that at least the videos of the openings and closings should remain available to the public. And I'm happy for him to consider that after we've delivered all of our closings.
Dr. Hub, I suggest you take instructions.
Exactly. It's not for me to consider, Mr. President, but for my client. We'll revert.
If I may say so, it's something to be considered. Because why would we do it differently for the present hearing as we did for the 2016 hearing? All right. Then one thing is we received the claimant's closing statements in PDF format. Gara, have you forwarded also that to Dr. Conrad and her team?
Yes, I have.
All right, okay. Dr. Conrad, can you confirm that you have received it?
We did, and we will submit at 11:50 a.m. Sorry, we received it at 11:50 a.m. and we will submit 1 hour into Vattenfall's closing to comply with the hour rule.
Okay, fine.
That is in PO 44. If my people don't fall asleep.
All right, Dr. Rapp, so Bear, MB, and I think Mr. Rielander, the three of you will do the closing statement. You have 1 hour for the matter and 30 minutes for the additional question, or for the Constitutional Court, I should say.
Yes. Thank you, Mr. Chairman. We have structured our our closing based on your questions. So Dr. Happ will start out with questions 1 and 2. We will say question 3 for our post-hearing submission. I will deal with question 4, and Mr. Rylander will deal with questions 5 and 6. And I will come back with a few concluding remarks. And thereafter, Dr. Happ again will come back and talk about the Constitutional Court. So, Dr. Happ, please.
Professor Bear, thank you very much. Members of the tribunal, you've asked us 2 sub-questions in the topic A, 1A and 1B. And 1A is a very simple question. What is the legal basis for awarding damages pro rata, the shareholding percentage in claimants 4 and 5, as advocated by respondent? And our answer is that's a very good question, and you should primarily ask Germany. It is Germany which has advocated this novel theory that the foreign-controlled but locally incorporated subsidiary, which is a claimant under Article 26.7 ECT and 25.2b of the Exit Convention, can only claim damages pro rata. There is, as we have explained several times in our written submissions, no legal basis for that theory. It finds no support in the wording of the treaties, nor in decisions of other tribunals, nor in academic theory. And I can refer you to the sources which you see on the slide. That is, for example, claimant's reply, sections M43, our rejoinder and jurisdiction, D34, and our closing statement in 2016. You might recall that we extensively discussed the structure, for example, of Article 26 ECT and how Article 26.7 operates. We also expounded our country view, namely that claimants C4 and C5 can claim 100% of their own damages, as you know, in a response to the Arbitral Tribunal's questions 1 to 8 and further submissions, latest in the Escosol case. Unless, Mr. President, you or your colleagues have questions regarding this, I would move on to topic 1B.
Dr. Happ, if I may,
yes.
Escosol is what we may call the horizontal problem. So it's only in our case that the Escosol addresses C2, but Escosol, if I'm not mistaken, addresses not C3, C4, and C5 situation, which you may call the vertical situation. Will you see a difference?
Well, as far as I recall it now, we explained in our accompanying letter to Escosol that the issue whether a local subsidiary which is not 100% foreign owned can nevertheless claim 100% of the damages. And that is what we have explained in our letter of 9th October 2020.
Dr. Happ, is it also my recollection correct that in Escosol the Arbitral Tribunal was a bit uneasy about the question, to put it in some colloquial language?
Mr. President, I'm not sure how you come to that conclusion, but the point is that our view of how Article 26.7 is to be interpreted, how it works, is independent from Escosol. We've argued that position already 4 years before we submitted the Escosol award.
Thank you.
Yep. Thank you. With your leave, then I would move on. And you have asked us how a prorated recovery for C1, C2, and C3 would fit with compensation of C4 and 5 for 100% of their losses. And I understand that term prorated recovery, meaning that C1, C2, and C3 will only claim their own damage, which is a shareholding percentage pro rata of C4 and C5 because they file indirect claims. We think that fits perfectly well and it is no problem. The reasons for that are as follows. In their memorial, claimants had originally filed only one prayer for relief, requesting payment of one total amount of damages to C1 and C5 as joint creditors. With their reply claim and in response to Germany's objection on jurisdiction, they have filed staged prayers for relief, which we latest updated with our letter of 19th November of 2020. And if you look at the wording, you notice two things. Firstly, they are staged prayers for relief. The main prayer for relief is that all 5 claimants jointly request that payments should be made to C3, Vattenfall Nuclear, for its damages relating to Brockdorf, to C4, that is the criminal OHD, for its damages relating to criminal NPP, and to C5 for its damages relating to Brunsbüttel NPP. If you were to grant that prayer for relief, and once Germany has made payment, by extinguishing the damage which C3, C4, and C5, in particular C4 and C5 have suffered, also the indirect damage suffered by claimants 1, 2, and 3 will be extinguished. And this goes subsequently, then the subsequent or further prayers for relief are staged. If you, for example, find you have no jurisdiction over claimants C4 and C5, then we ask for payment of damages to C3 for the damage it has suffered. And with payment to C3, damage of C2, the direct mother company, Vattenfall GmbH, and C1, Vattenfall AB, would also be extinguished. And you also note that all the prayers for relief are specifically therefore formulated. For example, the primary prayer for relief, that's 1B lit IA, says to criminal OHD an amount of 3,950,634,132 for damages relating to KKK plant. All further requests are identical, and also the subsidiary requests are identically formulated. All requests relate to the damage which a claimant has suffered relating to the plants. So we believe, Mr. President, that fits perfectly if you award 100% to claim of their losses to claimants C4 and C5, that at the same time extinguishes any damage which C1, 2, and 3 might have suffered. Does that answer your question?
Dr. Simply for my understanding, if C1 had been the only claimant in this case, and C1 is a foreign entity, is Vattenfall AB, and C2, 3, C4, C5 would not have been claimant in this case. And assuming that, without deciding on this, but assuming now that C1 would prevail, would the difference have been in monetary amounts 1.9 billion, approximately, in this case? That they would they get less than if you have here C2, 3, 4, and 5 in?
Well, not for C1. C1 can always, in every cancellation, only claim for its own damages. And even if the total amount is paid to C4, insofar as any money is distributed at all, C1 would only receive its share of the damage.
Yeah, and so
because it's a shareholder.
Yeah, and same with C2. Now take C2 and you take out C3, C4, C5. Would the difference have been 1.9 billion, approximately?
Not necessarily. We are now speaking, of course, about a hypothetical situation. The Krümmel plants and the Krümmel plant and the Brockdorf plant are, in our view, not only investors, but they're also investments which are indirectly owned and controlled by claimant C1, for example. And then, at least according to the wording of the treaty, but we have never put argumentation on that basis, C1 should have been Vattenfall AB should have been able to claim for the whole damage its investment, the controlled investment the company suffers. We have, however, based since it not on the KKK being an investment, but on KKK simultaneously being an investor. Legally, we believe it makes no difference because the crucial legal element, which is the same in both the scenarios, is whether Krümmel is controlled. If Krümmel is controlled, it's an investor and an investment. And then even C1 can request that full damages are paid. And of course, and we think it's so self-evident that we haven't even never seen the necessity to explain it in detail. Any payment of the total damage of Krümmel must be made to Krümmel regardless of who files the claim. Otherwise, the money which might be due, for example, to creditors, insolvency administrators, whoever, I mean, it's a general idea in investment arbitration, they would be deprived of this.
Is that right? And if the claimant is C1, why would the payment not be made to C1 in respect of the losses that C1 has suffered?
Wait a second, I need to read this. That, Mr. Professor Lowe, is our prayer for relief number 1B5. In the event that the arbitral tribunal were to find that it lacks jurisdiction also over Vattenfall GmbH, an amount of 3 billion for tax for damages relating to Brockdorf, Krümmel, and KKB plants. So we have filed this, but in our view, it's a subsidiary prayer for relief.
And arises only if the tribunal lacks jurisdiction over C4 and C5.
That is the way the prayers for relief have been formulated. We could have certainly filed it differently, but once again, with our primary prayer for relief, all claimants request compensation, and since C4 and C5 can request 100% of their damages, while C3, 2, and 1 can only request a percentage, since they have indirect claims. The joint prayer for relief is that the money is paid to the plants. That is where the primary damage has occurred in the first instance. And thereby the damage of all the other claimants is extinguished. So it's not as if C1 only requests damages if all the others have no jurisdiction. C1 always requests damages. The difference is to whom the damages are paid and what the amount of the damages is.
But let me carry on.
Okay. Mm-hmm. So members of the tribunal, each claimant claims for 100% of its own damages. The amount might vary, but Krümmel OHG claims for 100% of its damages. Brockdorf claims for, Brunsbüttel claims for 100% of its damages, and Wene claims for 100% of its damages. It's only that we have a kind of joint payment request in our primary prayer. So all 5 are claimants, all 5 claim as investors, all 5 claim their damages. The stage prayers for relief just differ in how much is requested and to whom it is going to be paid. But we have, from the beginning on, said we request joint payment always to an individual claimant and not splitting up any amount between various claimants. Mr. President, members of the tribunal, this has been some dry stuff. Have I answered your question, or can we continue with issue number 2?
Yeah, Dr. Happ, let me be clear about the effect what you are now what you are advocating all along. Actually, is that C5 is as 50% owned by C3, isn't it?
That is correct. Yes.
So, but then, and the other 50% is E.ON, or one of the other domestic companies?
That is correct. It's now called Preußen Elektra. Yes.
Okay, exactly. Yeah. That was a reason why I was not uncertain about the names anymore, but they change from name from time to time. But anyway, it's a domestic company, and so in this case, the effect is that whilst there's a 50% shareholding by the indirectly by the foreign investor, they get 100% damages reward in your submission, which would then mean also 50%, if I look to the shareholding, to Preußen Elektra, a domestic company, not being an investor under the ECT.
Mr. President.
Is that correct? But sorry, if my understanding is mistaken, please correct me.
Now, I need to phrase the answer carefully because I don't want to appear rude. It is both correct, but we think only half of the picture. Every time you have a domestic company which claims for damages because, let's say, it has been harmed by the state, or every time a foreign investor requires payment to be made to the domestic company, that money will never go directly to the foreign investor. If payment is made to a local company, there are various possible creditors who might get the damage. There might be domestic banks. In other cases, there might be domestic insolvency administrators. It is, in our view, completely novel and unheard of that the tribunal looks at who will receive the money and how much money flows only into foreign countries. That would kind of benefit the state if he causes damages to a local company, if he then does not have to compensate. If that company can claim and is an investor, if the kind of local damage suffered is not compensated, then that company would never be whole. I think we have. Sorry, yes?
No, sorry, I cut you off, Dr. Please continue.
I think, Mr. President, that we have pointed to this also in our briefs. Can I shortly ask how much time we have officially spent without the questions?
No, please proceed.
8 minutes.
Okay. Then, if I may, I would proceed to issue number 2, which is, in a similar way, both simple and complicated. Issue number 2 is your question how we are to distinguish between the consequences that flow from certain developments, which are lawful, and the consequences of the unlawful act. And I'd like to go back with you to the basics, and then look at the specificities of this case, because really then it gets very simple. The crucial element which divides both sets of acts, the consequences from lawful acts and the consequences from unlawful acts, we believe is the valuation date. Everything which happens before the valuation date, and which must be lawful, because the valuation date is always before an unlawful act. So every development, every consequence happening before the valuation date forms part of the factual matrix of the valuation. It is taken into consideration and is part of both the actual and the but-for scenario. Events which happen after the valuation date, even if they are lawful, are irrelevant unless they are foreseeable. Then they become part of the factual matrix of the valuation date. What does that mean for our case? Well, the Fukushima accident
I'm
lies.
sorry, I
Yes.
don't want to interrupt, but the transcript has not got what were pretty critical words. You said events which happen after the valuation date, even if they're lawful, are irrelevant. And I think you said unless they were foreseeable. Is that what you said?
That is correct. That
Could
is
you
correct,
repeat
Professor
that
Lowe.
sentence, please, because I think it's
Yes.
crucial.
Events happening after the valuation date, unless they are foreseeable, are irrelevant from the point of view of the valuation date. So that means the Fukushima accident lies before both discussed valuation dates, i.e. March 14th or June 29th. Under both scenarios, the Fukushima accident is part of the factual matrix, and it must be included in both the actual and the but-for scenario. And the impacts and developments coming from Fukushima, if any, must be accounted for in the valuation of claimants' investments. After the valuation date, as I said, any impacts which occurred at the valuation date will continue in both the actual and but-for scenario. And since any consequences of Fukushima are included in both scenarios, that means that Germany is not held liable for the consequences of Fukushima. This is as it should be, and we respectfully submit that no disentanglement must and should be made. As you know, Professor Lowe, the only difference between actual and but-for is the unlawful act and its consequences. If we establish the but-for scenario, we only deduct the unlawful act and its consequences and nothing else. If we were to deduct other consequences or other facts, then we would not compare actual and but-for.
But isn't it your argument that the value of the investment by June 2011 had already been reduced by the anticipation of the adoption of the measure?
Professor Lowe, you're touching an important point. What we are saying is something which is prescribed by the Energy Charter Treaty, since we need to have a valuation date which gives you an indication of the kind of fair value unimpeded by what the state does or plans to do. Article 13 of the Energy Charter Treaty instructs you to select a specific date where the market value is unimpeded.
In cases of expropriation, but...
Exactly. So what we say is, and what my colleague Mr. Rylander has pointed out at the in the opening statement again, is that the market anticipated the measures. What we further say is we do not know what the impact of that anticipation is, and that there is no evidence also from respondent that there is a determinal impact. When we say we should move the valuation date to 14th of March, that is because we say that this is the date where you as a tribunal can be sure that there is no impact of the expectation of the measure. Let me turn that around. If you were to select a valuation date of 29th of June, then you'd have to find that this is the date where the expectation of the 13th Amendment did not influence the value of the investment. And then you'd have to take into account all developments which have taken place until the valuation date. That means that if the electricity price, as it seems, has risen in the meantime, you'd have to calculate and value damages for criminal on the basis of the higher electricity prices. It has been our position that this is not right, since the data is so confused and tangled that it's neither possible to say that there has been an influence or that there has not been an influence. And that is why we say you should go back to 14th of March. And we further say, and I'm now leaving kind of my slides. I think, however, we have put this on a slide, and I'm asking my colleague to go to, wait a second, to go to slide 12, please. Yeah, so if you were, our position is that if you were to select the 29th of June, then in order to come to a correct valuation of the plants and then its emission damages, the tribunal should select prices of March 14th. Because this period of uncertainty in between, where the value might have been affected or might not have been affected, but it's not clear to determine. You're on the safe side if you go safe side of the calculation, if you go back. And well, Germany and the German Council has, I think, several times said that we do this out of the goodness of our heart. No, we base our claim on the law and on the treaty. And the treaty says you need to go back to a date in time where it's sure that the value is not affected either by the measure, impending measure, or by the knowledge of the impending measure. And we say this is 14th of March.
But that's then allowing questions of what arguably should be causation to be determined by the requirements of evaluation method.
Can I ask you to briefly explain that? I'm not entirely sure if I answer right now, I'll give you the correct answer. What causation of the damages?
I can see the argument that in order to get a pure accounting valuation date which excludes the possibility, we need to go back to March 2011 or to some time such as that. But even though that gives us what looks like a methodologically sound approach to fair market value, it doesn't address the question of causation, what actually was caused by the respondents' acts and what was the result of other factors. And another way of putting that would be to say, how do we know, or how are we to decide if any changes in the value of the investment between March and August were the result of anticipation of what the respondent did, or on the other hand, were the result of market estimations that something would happen, not necessarily a breach of the treaty, in relation to Fukushima, that there would be a tighter and more expensive regulatory regime.
Okay. I understand that. Can I answer in two parts?
Can I just say I'm very grateful for your flexibility in with this question. No, thank you.
I think the first point is that we need to be aware of what the measures did. And can my colleague please go back to slide 11? And the point is, if you want to differentiate between to see whether there's something in actual or but for which might not be accounted for, the first relevance is what are the effects of the measures, and is there something else which might have caused that? Now, the measures are quite explicit. It's the revocation of the lifetime extension, it's the permanent shutdown of the old plants in Krümmel, and the hard shutdown dates for the remaining plants. We submit nothing on the record, no fact pre-29th June, which might have caused that. There was, of course, the moratorium, but the moratorium was limited in time for 3 months. It ended on 17th of June, 2011. So if you ask about causation, then Priscilla, it's our position there's no other factor on the record which might have caused what the measures have caused. And if we look at the effect, once again, it's our position in that, and Mr. Kaczmarek has, I think, testified on that. With the valuation date as of 29th of June, the value, the but-for value without the measures, would be 700 million euros higher. You have to imagine briefly what the but-for scenario means. That would mean that Krümmel was affected by the moratorium was lifted, and then there would have been notice there will be no shutdown, Krümmel can operate again. And of course, it's then on the basis of the electricity prices as of then. And I think it's, well, now I'm leaving the territory of legal argumentation. So will not discuss whether a buyer which knows that the plant will not be shut down will attribute to the lower value. I find this unlikely. The other point is what you correctly say, what is the possible causation of Fukushima with regard to retrofitting? And can my colleague please go back to, let's see, sorry, to slide number 7 again. So it is our view, if you look at this from a purely not dogmatic but legal point of view, then we need to discuss whether there might be anything in actual and but-for. Well, any consequence from Fukushima will be found both in actual and but-for. That's necessary because Fukushima is before the valuation date. And it's not to be taken out because it's not an unlawful measure. So is there something which you might have overlooked? Some factor which is not in our calculation, which you cannot find in actual and but-for, which might reduce the value? Well, we don't think there is any. And if we look at the next slide, I'll explain why. As we understand Germany's assertion, we have combed carefully through it with the narrow comb. Essentially, Germany says that Fukushima accident would have resulted in stricter safety requirements and additional costs. And what you see on the screen is from the second Harden report, and they basically said to expectation of stricter safety requirements and additional cost burdens following Fukushima. Now, what do they say? And we move on to the next slide, please. What are those post-Fukushima effects? And those are basically expectation for tests. You see that that's from Dr. Grau's report, which is ex post. So it looks explicitly like what followed from Fukushima. And we're using this now just again, we are not admitting that this should be made ex post, but we think it clarifies what might have been expected. So some seismic instrumentation, it says a demonstration of ground acceleration, tests for an airplane crash. So it's just basically an evaluation following from the RSK report and the NSREG report. And that is, my colleague advises me, it's from the 2016 hearing. So what you had on that slide. Now, this is ex post. So whether they could be expected as of 14th of March is unclear. As of 14th March, some testing certainly could have been expected. And for the purposes of this exercise, we're willing to admit, yes, some tests could have been expected. But the costs, if you look at this, are rather minimal. Yeah, it's robustness demonstrations of the RSK, it's 50 million. The total sum is negligible in the overall amount. And what is most important, you have on the record the cost statement by Dr. Neumann from 2015, which is, I think, claimant's expert report number 9, which says that all those alleged additional costs are covered by the existing budget. So, Professor Lowe, to answer your question, there might be consequences coming from Fukushima, such as testing requirements, but Germany's own reports say that the post-Fukushima requirements are minimal. And we have submitted evidence already 4 years ago that the existing budgets of the Krümmel plant, which were drawn up before Fukushima, were more than sufficient to cope with everything which was submitted post-Fukushima. Now, that was a complicated tour back and forth through time. Do you have questions?
Very helpful. It's been, and I'm grateful for your flexibility. Thank you.
Good, thank you. Can I ask my colleague briefly to move on? We have looked also at other possible consequences. That is the second leg of your question. Wait, unspecified conditions. I just need to, since we jumped back and forth, I just need to find where exactly I am. Stay with me, please, for a minute. Yeah, you heard the evidence of Ms. Harden and the testimony of the cross-examination. So I think you understand now our position that we say there are no direct consequences for significant consequences for claimant's nuclear power plant. We know that on the international level, and I think what's important is to always consider that we have here a special case with the Atomkonsens. The Atomkonsens, and that addresses, Mr. President, a question which you asked about public antipathy against nuclear power plants. The Atomkonsens had been concluded in 2002 to create peace and end a 30-year discussion about the future of nuclear power, and it had given certain guarantees. Every buyer of a nuclear power plant could have relied on that, and we know that the Constitutional Court in Germany in 2016 decided on the basis of the Atomkonsens to say that this created legitimate expectations which shouldn't have been reached. So if I may briefly move on to the second part of your question, the consequences of the measures are removed from the but-for scenario. One second. So I've briefly discussed it already some minutes ago. The direct consequences of the measures are in our but-for scenario removed, and there's no other act on the record which is similar and has similar effects. And that's why we think 14th of March is the proper valuation date. Next slide, please. If you take 29th of March, 29th of June, the damages are higher. But we believe the best approach, if you were to choose 29th of June, is to take market data from 14th of March. But even that is only a compromise. Properly speaking, once you go back to take market data from 14th of March, you'll admit that there might have been an impact, and then 29th of June cannot be the date. So next slide, please. That, Mr. President, members of the tribunal, concludes my explanation of question 2. I hope I have answered your questions. If not, I'm happy to answer that, or we will address it in our post-hearing submissions. Thank you very much.
Thank you. Who is addressing question 4 on the?
I will do that, Mr. Chairman. But before I start, maybe you could have a time account. I mean, how much time have we spent so far?
Gara, can you give an account?
Yep, 18 minutes so far.
Okay, thank you. Yes, I will address question 4, the main points from the testimony in this case, and I will start with the testimony of Ms. Harden. There are indeed many takeaways from the cross-examination of Ms. Harden in this case, none of which is actually positive for Ms. Harden or for the respondent. For purposes of this closing, we will limit ourselves to addressing some of these takeaways. A complete list will be provided in our post-hearing submissions. First, as a general observation, it became evident that Ms. Hardin's calculations and analysis are flawed in many respects. As the tribunal will recall, during a cross-examination, she had great difficulties providing straightforward and meaningful answers to the questions put to her. One illustrative example is when Ms. Hardin first agreed that the actual values of the plants by definition have to be the same regardless of whether you are in the OPV only or the LTE scenario. Then, when confronted with the repeated error in her models that was not fully fixed in her report, in her fourth report, she refused to concede it was an error, and then in the course of the question changed her mind on the substantive point. First, she confirmed that the actual value in the OPV only scenario and the OPV plus LTE scenario should be the same, only to flip-flop on that statement when confronted by the fact that this was not the result of her model. When pressed for an answer in a cross-examination, one preferred escape route was to say that she did not recall. She made use of that response in no less than 22 times. Although clearly being no Maradona, Ms. Martin perhaps was hoping for the hand of God to come to rescue. Another escape route was to avoid an apparent error by saying that the point, as she called it, that she supposedly was making was something else, as if that would somehow excuse all the errors she made in relation to whatever point she was trying to make. I think the bottom line here is that the testimony she gave was simply far from what the tribunal has the right to expect from a financial expert in a case such as this. It was not even close to inspiring any form of confidence in the work that she has done throughout this arbitration. The second takeaway is that Ms. Hardin's testimony confirmed that she has failed to reflect on whether her calculations and models generate a result which makes sense and can be viewed as reasonable. Let me just provide a few examples. According to Ms. Hardin, the value of the Krimmel plant in the actual scenario is positive in the sum of 280 million euro. She arrives at this positive number although Krimmel was permanently shut down by the 13th Amendment and would incur billions of euros in decommissioning costs. In other words, this means that Ms. Hardin would have this tribunal believe that a hypothetical buyer would pay nearly 300 million euros based on the mere hope that it could sell salvaged parts and stranded OPVs a decade later for an amount that would offset the decommissioning liabilities and provide a reasonable return. And apparently a hypothetical buyer is supposed to do this with the future market clearly being a buyer's market, with the 13th Amendment, with half of the German MPPs being shut down and with hard shutdown dates. By contrast, Ms. Hardin concludes that the actual value of the Brookdorf is negative in the sum of 500 million euros. Just to recall, Brookdorf was not immediately shut down by the 13th Amendment. Ms. Hardin assumes Brookdorf would operate for an additional 10 years until 2021. And throughout this arbitration, Germany's technical experts have opined that Brookdorf is by far the superior plant with a better operating history. When it was pointed out that the lower value of Brookdorf directly contradicted what she had written in her fourth report, she was at odds to explain this apparent contradiction. Ms. Hardin tried to make up incorrect justifications as she went along, suggesting that Brookdorf does not operate as long as Krimmel because it does not have access to volumes, when in fact her assumption in her fourth report was the exact opposite. Another example is Ms. Hardin's conclusion that Krimmel would be 1.5 billion euro better off with the measures than without. The result is clearly illogical. But what is perhaps even more remarkable is that Ms. Hardin could not even remember whether or not this was the result of her own calculation. Yet another example is when Ms. Hardin was taken to the statement in a report where she argues that the reason why Krimmel is better off in the actual scenario is the nuclear fuel tax. However, when confronted on this point, she had to admit that, and I quote, "I don't know if that's a necessarily true statement," which we can see here on the slide. A further example of an illogical result of Ms. Harden's valuation is that she attributed a higher but-for value to Krimmel in the OPV scenario than in the LTE scenario, meaning that the NPVs, the new volumes, have been given a negative value. When confronted on this point, she had no explanation to offer. So what conclusions can we draw, or can you draw, from Ms. Harden's testimony in this arbitration this week? Well, it is clear that Ms. Harden reaches illogical and unreasonable results in her valuation, and the reasons for that are several. One important factor is that she has been driven by her goal-oriented adjustments, adopting any measures whatsoever to arrive at the damages figure of no more than 0. No doubt this has also been the instructions given to her by respondent. Her testimony also made it clear that a goal-oriented approach has forced her to change and adjust her valuation and model numerous times over the past years. The pattern is evident. She has lost track of what she's doing. Just look at the significant differences between the adjustments she makes in her third and fourth reports. We illustrated this in our demonstrative exhibit number 5. And this is what happens when you do not approach the task at hand in a professional and objective manner, but rather work backwards based on a result which is predetermined. Ms. Harden has also failed, as I just mentioned, to take a step back and reflect on whether the result she arrives at makes sense. Any financial expert must do so, but Ms. Harden and Germany seem to believe that doesn't apply to them. As long as the end result is no more than 0, any number, any calculation, any assertion is up for grabs. Furthermore, Ms. Harden has misrepresented statements made by Mr. Kaczmarek. In a fourth report, she alleged that Mr. Kaczmarek in his fourth report had reversed his position by confirming a potential future demand for the OPV. However, as became clear at the hearing, Mr. Kaczmarek's position in this respect has been consistent ever since his first report. Ms. Harden also alleged that she had identified several major European utilities that declined in value after the Fukushima accident. However, when asked in cross-examination, she could not identify a single such company apart from EDF. Another conclusion is that if the tribunal before this hearing had been considering to use Ms. Harden's model to make certain adjustments to Mr. Kaczmarek's calculations, I say this must clearly be off the table now. The logical results of Ms. Harden's calculations are simply too ingrained in her calculations. In fact, embarking on any such exercise would serve as a great injustice to the entire quantum phase that we've gone through in this case, which must, in our view, be based on evidence and solid calculations, such as the ones provided by Mr. Kaczmarek. Let me then briefly look at the testimony also in relation to the alleged portfolio effect. To recall, in its final Q8 submission, Germany came up with the argument that there is a 2 to 3 billion euro portfolio effect. Germany also says that the only reason this alleged deduction has not been included in Ms. Harden's model is because the damages are already negative. However, Ms. Harden confirmed during cross-examination that she had not even been asked to consider the alleged portfolio effect. And she said, honestly, I was not asked to look at the portfolio effect and add it into the damages. So if I'd been asked to do that, I would have done that. She confirmed that the portfolio effect was something that Dr. Cohen had calculated. And she was asked the question, and you refer to Dr. Cohen's assessment for your statement in his section, right? Yes, she says. This was a calculation performed by Dr. Cohen. You can see that on the slide. But we know from Dr. Cohn's reports that he's only concerned with power prices. And what he has come up with is referred to by himself as merely an indication of materiality. That's in his fourth report, paragraph 307. His own analysis is that the difference between but for and actual electricity prices is a mere 1%. And his own analysis of the alleged portfolio effect is that it is 193 million euro. It also became clear from the testimony of Dr. Cohn that the indication of materiality referred to by him did not include taxes nor costs for CO2 emission certificates. And you see the questions and answers on the slide there. As regards to CO2 emission certificate costs, Dr. Cohn sought to downplay the significance of these costs. However, the fact is that he did not consider them in his calculations, and we submit that they would be a significant factor to consider. The conclusions we can draw then from this is that there is no expert evidence in the record supporting the alleged 2 to 3 billion portfolio effect. What we do have is an incomplete and incorrect indication of materiality of Dr. Cohen's, whereas his own analysis, as I just said, lands at 193 million, which Ms. Harden has not even been asked to consider. Finally, Germany decided not to put a single question to Ms. Kaczmarek on the alleged portfolio effect, clearly afraid of what the answers might bring. And by that, I hand over to Mr. Rylander, please.
Thank you. And I will turn to question 5. And this question, as we can see, has to do with how to treat claimants' offset implementations in the event the tribunal would assign some value to the OPV in the actual scenario. And I will start with the basic answer, and it's this: value and offsets are mutually exclusive. So if some sort of value of the OPV is included in the valuation, there cannot also be offsets. That would be a double reduction of sorts. So that's the short answer. But considering how this question is phrased, I want to expand a little bit on the relevant value here. Now, claimants maintain that no fair market value can be assigned to the OPV as of 2011 in the actual scenario. I addressed this in our opening. Mr. Kaczmarek explained it several times in his testimony, and I will not re-argue that here. You've heard all of that. However, I want to recall a few aspects that have also become clear during this hearing. First of all, it remains agreed between the parties that the relevant standard of value is fair market value. Ms. Hardin has stated already in her reports that fair market value is the standard to be applied. Here we have on the screen an extract from her fourth report, paragraph 4.10.1. And again, without going into the details of this, as Mr. Kaczmarek has explained, with the conditions in 2011, with no way to use or sell the volumes at that time, there's by definition no fair market value. And when asked by the tribunal members, Mr. Kaczmarek explained that this is the end of the road of the analysis. And he put it like this. And this is from transcript day 11. It may seem extreme at 0, but I'm following the rules. I'm not allowed to break the rules. I'm not allowed to maneuver ways and find creative solutions to things. I've got to follow the rules, and that's what I did. 0 is the right number for fair market value at that date. And it has also become clear that Ms. Hardin has sought to create a value which is not fair market value by inserting a fictional middleman who picks up the OEPV in the meantime. We can see on the left-hand side of the screen transcript from day 12, where Ms. Hardin explained, quote, "We're going to assume a hypothetical buyer that's going to buy all these volumes and then sell them to the plants that need them going into the future," unquote. But a fictional middleman does not make a fair market value transaction. And in this particular case, of course, it's not even legally possible to sell OPV to anyone else than directly to an operator of a nuclear power plant. And during his cross-examination, Mr. Kaczmarek dispelled the notion that one can create a hypothetical buyer when there is no possible buyer at all. As he put it, a hypothetical buyer is not an imaginary buyer. He explained, so hypothetical does not mean imaginary. In a fair market value analysis, you do look at generally what your relevant buyer pool would be to ascertain generally the size, and in many cases, it's significant. Your restaurant example, that could be hundreds of millions of people would be a potential buyer of a restaurant. In this case, when you look at it, it's one. But the hypothetical basically takes away the personality of the buyer, because what we're looking for is eliminating special characteristics of a buyer. But again, a hypothetical buyer is not an imaginary buyer.
I think my recollection is that Mr. Kaczmarek also said that the first question he addressed was what approach would be adopted to valuation, and that it was decided that fair market value was the best approach. Are you saying that if some other approach had been taken, we would have come to the same result?
Well, again, as Mr. Kaczmarek explained, it all depends on the standard of value. But for instance, as I believe he mentioned, if you would use fair value, the conclusion would be the same. But then there are, of course, other standards of value. And I can't say on the spot what the conclusion would be under all of those standards.
Because it's only fair to say what is doubtless obvious, that I find it troubling to think that because something cannot be valued, it therefore follows that it has no value. And those seem to me to be two different questions.
Yeah. Should I expand on that now, or I think?
As you choose. I've done enough to.
No, I mean I believe we have noted that, and I don't know if there's much I can add to it, but again, the key point is perhaps not that something cannot be valued. Is you look at the relevant standard of value. In this case, you need to find a hypothetical transaction where you assume a willing buyer, but the willingness must be rational. And in this case, at the valuation date, there is no rational willingness from anyone to buy. But again, I think we have covered that at quite length earlier in this hearing.
Please carry on.
Sure. Well, then, if the tribunal nevertheless, despite these factors, were to find that the OPV have a value or some value, whatever that value is, that value in any event is not the figure alleged by Ms. Hardin, we need to point out. Well, first of all, just as a general matter, Ms. Hardin's calculations as a whole are simply not reliable. Professor Aber mentioned some instances from the cross-examination the other day. And when it comes to the OPV, Ms. Hardin's projection of a €1 billion value, those are based on an estimate that claimants would obtain sales proceeds in 2019 and onwards of a total of 2.8 billion euros. And we say that that's simply not realistic. And again, I'm not going to go into the details of the flaws in Ms. Hardin's analysis. We've covered it at length in our written submissions, and Mr. Kaczmarek has explained it in his reports and also at some points in his testimony. So I'm not going to go back to that. I also illustrated in our opening how Ms. Hardin's assumptions have changed constantly throughout her reports. Just goes back and forth. So again, I'm not going to repeat that here. I just want to point to it. But one thing I want to mention, though, on her analysis of the valuation of the OPV, that has to do with the so-called monopsony market. And my point here is just that one of Ms. Harden's recurring arguments has been to question that there would be a monopsony market. And a monopsony market, of course, is a market with several sellers, but only one buyer. Still, in her reports, she has even confused these matters and argued that monopsony concerned several buyers, that is the opposite, and that these will be colluding to lower the price. We have on the left here a screenshot from Ms. Harden's fourth report. And when I put that to her on cross-examination, she tried to say that this was just poorly worded. You see that on the right here. But in fact, as we can tell, I think it's obvious from just this extract from a report, this has nothing to do with choice of words. Ms. Harden has a whole monopsony discussion based on an idea that there would be several buyers colluding. So this is not a matter of wording. This rather shows that she does not grasp these concepts, which she herself argues extensively in relation to the valuation of the OPV. I just wanted to point to that as an additional item. So in our view, the fact remains, if any sort of value were to be assigned, it can under no circumstances be Ms. Harden's alleged value. And then, again,
Mr. Reilander, so
sure.
According to claimants, if any value would have to be assigned, is that what Mr. Kasmajek says, what he calls then the real world proceeds of 7 billion, or 0.7 billion in slide 27? Is that your submission?
No, we're not making any submission about what such a value would be, because our view is that there is no such value, and that's not the right way to approach it. So we're not.
Do you give an alternative? You say, well, if there's a value, it is not Harden's value, but so then what is then claimant's proposal in the alternative for a value?
Yeah, sure. And I'm actually going to get to a sort of similar type of discussion right now. Actually, we are not putting another figure into this case because in our view it's clear that you need to work with the applicable standard of value, and that means 0. And we have our position being that you will deal with any proceeds coming in through offsets.
But is that alternative? If you don't give for the claimants a figure, are we not then forced as tribunal to adopt Ms. Harden's figure?
No, certainly not. Since we have pointed out both.
So, I thought that would be your position, but then please do give us a figure.
Sure, I will for sake of illustration, also go into some figures here, just to sort of illustrate the range that we're talking about here. But I just want to be clear that it's not something that we're suggesting as being claimant's value for these OPV.
Yeah, but be careful, Mr. Reilander, if I may say so. If you do not give a figure, you may force the tribunal to adopt Ms. Harden's figure. Because then you leave us with a binary choice, either 0 or 2.8 billion.
No, I would disagree from a procedural perspective to begin with. If our position is that you should stick with the fair market value standard and adopt 0, and Germany presents a high figure, we criticize that figure and show that it's unreasonable. But you nevertheless want to go sort of down that sort of non-fair market value route, then you're certainly in your right to set a lower figure.
Okay, thank you.
And this is actually what I want to illustrate here, because if you want to step outside a pure fair market value, and we could illustrate by looking at the data that we have to sort of get a grasp of what this represents if we discount figures that we have back into 2011. Just sort of do that exercise. And first, before we look at what we have on the screen here, we of course know that Krümmel has sold 24 terawatt hours. And they've been sold at the price of 27.83 euro per megawatt hour. But I should mention that price is being challenged by E.ON. It's being litigated, and E.ON claims a lower price or even to get the OPV for free. But at least we have that preliminary sales figure. And also, if there are further sales in the future, that price may well be lower. Again, E.ON is challenging the price, and we have the Constitutional Court that in its recent decision confirmed that this monopsony situation remains in place. And I should mention here again that Ms. Harden has not considered that monopsony for her modeling. But let us just assume then for the sake of an exercise here that we go with this 27.83 euro, even if it may well be lower in the future. And when it comes to what volumes to expect in the future, again, then even if we were to assume that the volume assumptions that Germany itself points to are appropriate, what would that be? And that's when I want to look at this slide here.
Mr. Rylander, before you then continue, what we see on this slide here are the 24 terawatt hours that is sold by Krümmel, the OPV, to E.ON?
No. I can perhaps take it from scratch.
But,
I think that's
sorry,
easier.
But this is you just said is that 24 terawatt hours was sold for 27.8 euro megawatt hour to E.ON by Krümmel, OPVs. Is that correct?
Yes.
All right. So my question here, so in that sale occurred in 2019, 2020?
Sorry, can you put that question again?
And that sale occurred in 2009, 2020?
Yes, that's correct.
So, and is it then your position that this sale, these sales, it was because I understand the series of them, were not foreseeable or could not have been foreseen when in June 2011?
That's our position. I mean, that's sort of you could look at it as a second step. That first of all you have the fair market value standard, and its rules. But then also if you sort of put that to the side and just see, okay, can we generally try and find a future hypothetical transaction? It's not fair market value. Then the uncertainties when you're standing in 2011 are too large to sort of try and find what the volumes would be, what the price would be, and so on. So certainly that's our position as well, that this is not foreseeable as of 2011. It could be expected, as Mr. Kaczmarek has explained, as mentioned ever since his first report in 2013, that there might be some demand in the future. But to take that potential demand and turn it into a precise analysis of what would be, how much would be sold at what price and to whom is a different matter.
Yeah, but that's a position, the zero value is a position that even Mr. Kaczmarek characterizes as extreme, isn't it?
No, I don't think so. I think he was answering, he was commenting on that choice of words. It was not his.
Okay, right, okay, fair enough. But please proceed. Sure.
So if we look at this then, this is exhibit R326. You may recall it from Germany's opening presentation. And Germany has relied on this on an alleged demand by E.ON from this investor presentation. And first, as perhaps a side note, in Germany's opening, Council said that this document has to be correct, otherwise there's a pain of potential criminal liability. And we just note that at the final page of this presentation, there's this disclaimer on the final page. But these are anyway the figures which Germany says must be true. So let's just have a look at them and we'll see where it takes us. And as we can see, here E.ON represents a potential total demand of between 45 and 60 terawatt hours. And that refers to 3 plants, 2 which have hard shutdown dates at the end of next year, and 1 which can run through 2022. Okay, and to get to this sort of relates to your earlier question. This document is from February 2020. You can see at that time, you can see on the slide here, there had been a sale with the preliminary purchase price of 10 terawatt hours. And since then, there's been 14 more, the total of 24. But again, as we can see in the note number 2 here, this indicative range of 45 to 60, that does not take into account transactions already made. So we need to deduct the 24. So now that will give us a let's put it this way. We will take this and in the next 2 slides, we can see, based on Germany's evidence, what this would mean if it's discounted back to 2011. Again, this is not a exercise of value. We're not suggesting that it's the right way to do anything, but it could be interesting to see what kind of figures we're talking about. And we'll do, if we can go back, please. And we'll do 2 things. First one, where at the high range, which would be sort of the maximum based on this evidence, a total of 60, and then one with a lower, where there's a total of 45 being transacted. Okay, we can go to the next slide. So we can start with the formula here. It's actually pretty simple. To reach a figure, some sort of figure, we put value in quotation marks here, but to reach some figure in 2011, we take the sales proceeds and apply a discount factor to sort of discount it back. And if this were ever to be used in some sort of valuation as per 2011, this sort of exercise, it would have to be an after-tax figure. So those are 2 things that sort of reduce the amount if you want to go from a sales figure to some sort of quote-unquote value in 2011. So I think that's important to keep in mind, that you see a sales figure in 2019 or 2020 says 100 million, but that if you want to go back to 2011 and bring that back, it's going to be much lower. It's going to be less than half. And I should say that this is the same simple formula that Ms. Hardin uses in her OPV calculation tab. So there's nothing controversial with the formula as such. Then in the table, we have first the 10 and the 14 that have been sold. And to get to a total of 60, we just, for simplicity, could allocate the remaining 36 with 3 quarters in 2021, because there's going to be 3 plants running and potentially, well, at most 1 in 2022. And if we add this up, you can actually do this on your pocket calculator. You get a figure as of 2011 of 653 million. And again, we're not saying that this is it's right to include a figure like this into evaluation, because it's sort of mixing the concepts. But this just illustrates that even if we take the most optimistic assumptions with a retained price level of 27.83 euros and the maximum figure from E.ON's estimated range, which Germany relies on, then first we need to take account of time value of money, and that translates into a figure which is in its range of 650 million.
Mr. Arena, one small question here on this slide.
Yep.
The discount factor, is that the same as used by the respondent?
They are, let's see if I remember correctly, I think there's a minuscule difference. Of course, I mean, you start with the discount rate and then you find a discount factor depending on which year you're in. But yeah, it's virtually the same.
Okay, thank you.
I actually wasn't planning on spending more time here. And the next slide, we've just done the same thing, but with the lower range, the 45 that we saw in the investor presentation. And we just allocated those 21 terawatt hours in 2021 and 2022. And that gives us a figure of 496 million. So if I go back to question 5, as you put it, well then, if some sort of value is assigned to the OPV, which we say would deviate from fair market value, then first of all, no offsets can be implemented. That's just a matter of fact. And we say that the value cannot be that suggested by Ms. Harden. It would be much, much lower. So unless there are any further questions, I would move on to question 6.
Right, Mr. Eilander, but not to answer now, but maybe in the later round.
Sure.
If the tribunal, without again saying anything about what we would do, but if we would have to put this figure into the Excel sheets, which asked for model questions, where would you put these figures? Of Mr. Kasmarek
Yeah.
and Ms. Harden. You don't need to answer it now because that's something.
No, I can answer it now. for this sort of this sort of exercise, I mean, if you want to put sales figures, Ms. Harden claims that they are foreseeable and she assumes them as of 2011. But the exercise is the same. Then there's a tab, I think it's called actual value of OPV in her model, where which is I would say an uncontroversial way. It's just bringing the figures back, really. So you can, if you want to test this, you can put these figures in. You'll see that the outcome is just as on the screen.
In the next round, please give us the exact row and.
Yeah, no, it's not just a row. It's a tab. It's in LH Appendix 47, actual value OPV.
Okay.
Could we take a short break, please? This is David.
All right. Let's take a 5-minute break. Gara, how many minutes do we have?
The claimants have used 48 minutes.
All right. Okay. 48 minutes. So you have 12 minutes left for your presentation and 30 minutes left for the constitutional court decision. Right. Let's take a break from 10 minutes then for the time being. Okay.
Kamera ist weg.
Professor Aubert, everybody accounted for on your side?
Yes, everyone is here.
Dr. Conrad, on the respondent side, everybody accounted for?
Ready to go.
Thank you. All right. Elender, please continue.
Thank you. Before I go to question 6, I just want to clarify one thing. As I said before the break, if you want to arrive at these figures, you could utilize, if you want to, or if you want to verify it, that tab in Ms. Hardin's model. But then when I look back at your question, Mr. President, you were obviously also asking where to put that figure that we that we derive, where to put that into the models. So I just want to clarify that figure would be a quote unquote increase in the actual value of the Kriml plant. And I say quote unquote increase because it's only makes the very negative value a little bit less negative. I think you're muted.
I was asking you for the specific cell, but
Sure, I can give you that.
You cannot give it.
No, in Mr. Kaczmarek's model, you will find his actual and but for values and everything in Appendix C1, and it's going to be Appendix C1 updated. It's the tab which looks kind of similar to the demonstratives that we showed the other day. We see all the final figures coming out from the model. So in Appendix C1, you will find that actual value of Kriml in cell C3. It would make that negative value less negative.
Okay, thank you.
Right. If we then turn to question 6. And here you're asking for claimant's approach to damages relating to salvage parts. And again, what to do with the offset implementations in case value is attributed to the salvage parts as of 2011. And I'll start with claimant's approach. And our approach is that any proceeds from the real world sales are treated as offset to damages. And that's what we've done by the offset implementations. And one thing to have in mind, I think, when it comes to the salvage parts is that many things at a nuclear power plant they're not off the shelf, so to speak. They're very plant specific. That goes certainly for a lot of the plant equipment, but also for perhaps most importantly the fuel elements. And I think that's important because when you now see that uranium is being sold, that doesn't mean that there's been a stock of uranium sitting at the plant available for sale on a market. The fuel elements that were left are plant specific, and there's no market where you can simply trade them. That being said, that there was, as of 2011, some potential to sell something in the future, and at least then from this inventory of fuel elements that could be disassembled into uranium, or back into uranium, perhaps I should say. But as of 2011, and indeed also later, it was too uncertain what the plants would be able to sell at all, and if so, what price could be achieved. So we handle the salvage parts by offsetting sales proceeds. And if we go to the next slide. Thank you. And this has been Ms. Hardin's approach also up until 2019 at least. Then in her report in 2020, Ms. Hardin argued that you should use the book value from the balance sheet. But as you may recall from the cross-examination the other day, I pointed out to her that the figure for property, plant, and equipment, which was one of 2 balance sheet figures she was looking at, that figure had actually been was actually 0 if you look at the balance sheet from the relevant point in time. namely when the 13th Amendment had actually been taken into account. So for what would reflect an actual scenario. She then instead acknowledged two things that we can see in the extract here. I'll actually start at the bottom. And that's first that accounting treatment is not an indication of value, which was a bit surprising because she had relied on accounting treatment figures. Secondly, that if you do look at accounting treatment, one option is to assign a value of 0 and account for the sales. That's the highlighted part at the top. And that's what we're doing here now as well. And then just the second sort of sub-question to question 6. Well, if a value nevertheless is assigned as of 2011, what do we do? Well, first with the offsets, again, value and offsets are mutually exclusive. So if salvage parts were to be included in the valuation, there cannot also be offsets. So then you would, just as with OPV, you would need to go back to the nominal damages amounts as of 2011 and work there, and then you will just have interest running on that nominal damages amount. So you would just sort of back out of the offsets. Now, when, again, as I mentioned, when Ms. Harden introduced her new balance sheet figure argument, she mistakenly relied on the balance sheet figures from before the measures, which would, if anything, be a but-for scenario. And now we're looking at the actual scenario. And as I mentioned, well, a minute ago, she then basically dismissed the entire relevance of accounting treatment as a basis for value. But nevertheless, if you would rely on balance sheet figures, I just want to point out that you must at least look at the figures which account for the measures. And that would be then those reflected in the balance sheet for 2011, not at the end of 2010, because we're in the actual scenario. And this reflects then how this is being treated. And we can see here in this extract from those balance sheets that, well, PP&E, property, plant and equipment, that's written off in its entirety. And then inventory, there we have a value at the end of 2011 of 92 million. I should mention, though, that this is a bit of an, we could call it an over-ambitious proxy of value, if anything. First of all, it doesn't consider that in order to resell the inventory, in particular the uranium from the fuel elements, that comes with a disassembling cost. And that's not sort of included here. And of course, we've seen that this book value is a lot more than a sort of 2011 value of all the sales that have actually taken place. And now we're 9 years from the measures. So whatever remains now is, of course, not the most valuable or easily traded items. They, of course, go first. I wasn't going to say more on this question. So unless you have any further questions on this, I will give the word back to Professor Aubert.
Unless there are no questions, then, Mr. Chairman, members of the tribunal, I'm thinking of the French philosopher Voltaire, who once said that the art of boring is to tell it all. So I will not say very much at all, except that we have, in fact, told it all, going back to our memorial from September 2013. We've told it all with respect to facts, liability, and now also with respect to quantum. And based on what you heard this week concerning the Q8 arguments, we believe that you will reach the right conclusion also with respect to quantum. Thank you. And now I hand over to Dr. Happ to discuss the Constitutional Court judgment. Thank you.
One second, please. Good. Members of the tribunal, we have listened with interest when counsel for Germany nearly a week ago explained or feigned to explain the relevance of the recent decision of the Constitutional Court. When you look at the slides of Germany's opening statement, you'll find that Germany mostly spoke about something else than about the recent decision. They spoke, for example, about the 2016 judgment a lot, but not about what you have asked them, the relevance. And therefore, we feel it's necessary to very briefly point out the two relevant points which Germany has completely omitted to mention. And one of them is a point where they even explicitly contradicted what the Constitutional Court had found. And that, I think, makes this case unique in the history of German constitutional law. The first is that on slide 41, I think, of Germany's opening presentation, Germany argued that the idea of a monopsony was essentially nonsense. Well, next slide, please. The monopsony, and that the 13th Amendment created a monopsony, was confirmed twice. Firstly, in the decision of 2016, which is on the file. And in 2016, they said, well, there are two potential buyers, E.ON and EnBW. And they can therefore largely determine the price themselves. And then, next slide, please. In its decision of 29 September, and that is the decision you asked Germany to comment on, it said even, now it's basically that E.ON now is the sole remaining party with demand. So the monopsony has been confirmed twice. And nevertheless, Germany in this hearing tells the tribunal there is no monopsony, although findings by the Constitutional Court are essentially binding. The second point of relevance has also not been addressed by Germany. Next slide, please. The second point is, at its essence, firstly, very simple. The court now has twice told Germany that it has to compensate claimants. And Germany doesn't say a single word about that, which leads us to the indication that Germany clearly intends not to pay any compensation at all, either in this case or in another case. But what is even more relevant is what the court and what you might consider an obiter dictum held. You will recall, members of the tribunal, that one of the flaws of the 16th Amendment, which we explained in our respective submissions, was what was called double deduction. Essentially, the 16th Amendment had determined, and you'll find it in the middle of the slide, that the amount of compensation payable to Krümmel or Brunsbüttel should be limited essentially to half of the electricity volumes of Krümmel. That is the percentage of its foreign shareholder. And in the proceedings, Vattenfall had pointed out that this would lead to a double deduction because you first pay 50% to Krümmel, which then needs to be split to the shareholder between the shareholders, which then means that the shareholder gets only 25%. And the court now did not have the need to decide this in the binding manner because it had found the 16th Amendment never entered into force. But what you see on the screen is its obiter dictum, which is for those who can read and know how a court writes, very clearly says that this is not okay. Germany tries in this proceeding the same tactic, a pro rata payment, than it tried in the Constitutional Court. There it already failed. Can you please have the next slide? Members of the tribunal, that essentially concludes a very brief observation on what Germany said a week ago in the opening. It still disregards the ruling, it ignores findings of a monopsony, and, well, although the German government said it would now soon find a new solution, there's a saying in English, I think, Fool me once, shame on you. Fool me twice, shame on me. Claimants do not trust that Germany will stop disobeying the decisions and come up with a solution and a compensation which is in accordance with that. As I said myself a week ago, this case needed to be brought and it's still necessary. Thank you very much.
Thank you, Dr. Abt. That concludes the closing statement by the claimants. Yeah?
Yes, that's correct, Mr. Chairman.
Thank you. Then, Dr. Conrad, how much time would you like to have a break?
Basically, the time that how do I put this in a public hearing without being crass? Literally 2 minutes.
Okay, but nonetheless, take 5 minutes.
I will take 5.
Thank you. All right, it seems we have everybody who was there before. Right. Dr. Conrad, please proceed with the closing statement for the respondent.
Yeah, I have two housekeeping matters before we start.
Sure.
One is as relates to the timing of the tribunal questions. So we've tried to preempt also the questions that you asked claimants. Should I ask you to ask so Yara can account for that? Or because otherwise, if I'm being responsive sua sponte, it cuts into my time and I'm being punished twice for trying to be helpful.
Don't worry, Dr. Conrad, you will not be punished.
Thank you very much. Secondly, we noticed that when it came to the salvage parts, Mr. Rühlander was offering new explanations as to what the salvage parts are. To my knowledge, that was new evidence. I'm not going to object now, but I have to reserve rights as to being able to reply, if necessary, in the post-hearing submissions.
Dr. Conrad, was it new evidence or new argument?
I believe actually it was new evidence describing, what happens to the uranium rods. I don't recall that having read that in the record. I haven't done a full search. What I do know is what we don't have the contracts for the sale of the salvage parts, nor, if I do recall, do we have an inventory of what they have, basically.
Right. Your objection is noted.
Thank you very much. And with that, I would be ready to start.
All right, we start now.
Mr. President, members of the tribunal, I'm trying to confine myself in my closing to answering the questions that you asked throughout the hearing. And for our closing, I will, and I've explained that earlier, not discuss the questions asked earlier this morning. Claimants did not answer your questions during the hearing. For example, when Mr. Rühlander was pressed about the disentanglement of things that are not caused by the measures, I don't think even now you received any straight answer. And indeed, I also note that claimants save the portfolio effect, which is very important, for their post-hearing submissions. So unlike us, who are going to foreshadow our argument, what we will hear from claimants will be new to us when we receive the post-hearing submissions. The relevance of the decision of the Bundesverfassungsgericht. What I can tell you is that my home state does not pass laws if they don't believe that they're constitutional, because we're a Rechtsstaat. We're a state under the rule of law, which is very important, actually, contrary to claimants' assertions, to my client, to the people that work in the ministries, and to the people that are our elected democratic representatives. And again, I have the express instruction from my client to repeat the commitment of Germany to implement the Bundesverfassungsgerichts decision of 2020. Let me, in this context of the Bundesverfassungsgericht, answer a question that Professor Lowe asked at transcript date 10/3027, line 18 to 21. So what position, he's talking about LTE, turns on their legal characterization as a matter of international law, in particular on the property and non-property part. The answer is in two steps. If we're dealing with not with tangible property. Property is defined by the national law. And international law takes that finding as it is. But then international law does a second step. And that is to check if that national right conforms to the concept of property in international law. For example, as has been the jurisprudence constante of the European Court of Human Rights, that a property right, especially if it's a public law claim, has to be underlined with investment-backed expectations, and no such investment-backed expectations exist for the LTE. Let me turn to contradictions of claimants with regard to the decision of the Bundesverfassungsgericht and the 16th Amendment, which they so vigorously and successfully fought in the national proceedings. That's transcript A10-2993, lines 12 to 19. We heard in their opening that they said the 16th Amendment was, and I quote, a new opportunity. This meant that sellers have not felt forced to sell at any price to avoid being left with useless OEPV. Also, Mr. Kaczmarek made that point. Second contradiction. You've seen what Mr. Happ said about the double reduction in the Bundesverfassungsgericht. We know about the double reduction argument of claimants with the OHGs, and I will give you more details later on. It's a problem of their own making. They would not have that problem had in this arbitration they brought Vattenfall ARB and their 100% owned, maybe even their 100% owned German subsidiaries. They've created that problem by bringing the OHGs as claimants. And the quote you see is from the post-hearing brief, page 69. The Bundesverfassungsgericht left the question open, whether as a matter of German corporate law, by the way, for which claimants bear the burden of proof in this arbitration, whether there is actually a twofold reduction. We had many experts, including legal experts from Vattenfall. We did not have a corporate law expert from them. And what you see also is that the Bundesverfassungsgericht characterized it as a complex, substantive, and legal situation that can be left open here. But it made clear in paragraph 81 that in fact the E.ON group should not have been allowed to receive any compensation. Indeed, it would exacerbate the alleged unequal treatment by Vattenfall. But in the present arbitration, they're claiming for Vattenfall's shares. And with that, I turn to question 1A, the legal basis for awarding damages pro rata as regards C4 and C5. You remember parts of this question have been discussed during the course of this 9-year arbitration. We have established, we believe, that there's no control in fact, that Article 26.7 only activates 25.2b of the ICSID Convention only for procedural purposes, such as jurisdiction, but not for substantive rights of the investor. 1.6 makes very clear the domestic entities are not investors. They're part of an investment, and only the part of it that has been invested by the foreigner. What if, in addition to 1.6, you wanted more reasons with that question? And there are indeed other reasons and other arguments why you should not award damages to the tune of 2 billion for domestic shares of a shareholder. One, and almost all of them, stem from Article 26.6, which refers in the applicable law for the ECT arbitration to principles of international law. Let's go through some of them. First of all, there is no precedent for any claimant ever recovering billions for the benefit of a domestic co-investor. In Kiborax, the case that was referred to by Professor Schroyer, who then didn't remember the BIT underlying it, only the 51% corresponding to the foreign shareholding counted. Escosol, the case that the president also referred to this morning, is different. Escosol was about the change of control by taking over by a national Italian host state insolvency administrator, receiver. So the host state takes over the subsidiary of the original foreign investor. You could argue that's basically a classical expropriation situation if you attack the decisions of the host state to impose an insolvency administrator. So the mindset of the tribunal was a completely different one in the Escosol case. And also in the Escosol case, even from the limited amount of information that's publicly available, it's clear that a large share of the creditors of Escosol were foreigners and from countries that have rights under the Energy Charter Treaty. That's not the case here. And again, and that takes me to the next point of venire contra factum proprium, they made their bed by using claimants C4 and C5 as claimants. Had only Vattenfall ARB claimed, the payment would absolutely, certainly 100% go to Vattenfall AB. By implying and including companies, OHGs, that also have E.ON shares, they invited the problem for themselves. In essence, they're trying to elevate a shareholder dispute with their German co-investor to an investment dispute, which would fail under 25 of the ICSID Convention, which is about a dispute arising directly out of an investment and not a shareholder dispute. Next point, round tripping, or to use a word which during the COVID crisis has gained some popularity, is so-called staycation. For older people like me, that's if you do a vacation without leaving your city and you stay in a nice hotel in the city you live in. We all know the controversy about round tripping, Tokyo's Tokeles. It has been raised under Article 17 in the UCOS arbitration. Here, that's all a fortiori. It may be contested where you have so-called treaty shopping if there is a foreign entity involved. Here, there's none. The German E.ON invested in German OHGs for German power plants without any treaty structuring, without any treaty shopping, not even together with a foreign investor. Their co-investor was HEV, a German company. It was only later that they found themselves together with a Swedish shareholder. And allowing the OHGs to claim for E.ON shares would be allowing E.ON to benefit from this accidental marriage and grant a completely domestic investor rights under a treaty. And there's veil piercing to consider. International law, and especially investment treaties, grant rights to beneficial owners, not nominal owners. And you could argue that 26(7) is a function of veil piercing. Let me refer you, for example, to Occidental and Ecuador, RL 109, paragraph 259. And I quote, "The dominant position in international law grants standing and relief to the owner of the beneficial interest, not to a nominee. The OHGs are fully transparent." Fully transparent is a term from German corporate law. And you will remember my exercise involving the whiteboard in Washington, taking Vattenfall's tax guy through what an OHG is. And I told you about the Gesamthands theory, something that German corporate lawyers hold very dearly and which is actually intellectually very pleasant and challenging. It is transparent as regards liability. It doesn't shield the partners in the OHG from any liability. It's fully tax transparent. All the income flows through and is netted at the level above. It is fully transparent with income. Those of us and those of the arbitrators who have been partners in international law firms know that we have to give tax receipts in very many countries of the world. this transparency, this veil piercing, would lead that, E.ON, the beneficial owner of 50%, would get compensated under an international treaty in a case against its own home state. You need to see who the real owner is as a matter of international law. And this is also in terms of the treatment of nationals in domaine réservé. Domaine réservé has been the non-interference in the internal affairs of a country. We know it's all controversial in the human rights area. We're not in the human rights area. Investment treaty rights are not erga omnes rights. They don't give rights to nationals of the host state. Investment law is different. Or to quote from Phoenix and Czech Republic, RL 123, paragraph 97, bids are not deemed to create a protection for rights involved in purely domestic claims, not involving any significant flow of capital, resources, or activity into the host state's economy. E.ON's money always stayed in Germany. And that this is no different for the ECT, referred to Professor Pelé, who said that in relation to the Yukos case. Domaine réservé. Many international lawyers, me included, and my country, do not like if states claim that the human rights are domaine réservé internal affairs. However, think of it from a policy perspective. Many of those countries, they do not subscribe to access to international courts and tribunals for human rights, have BITs. So they know that if you extend it to domestic shareholdings, they may have an issue with domaine réservé, because you can, if you want to, and I've written on that, you can try to bring human rights claims under investment treaties. So what would that be? You would see perhaps bids being terminated, especially in the part of the world that has rule of law problems. Thus, this would be leading to an erosion of international law. By expanding to E.ON shares, you create a fear in those states, which would end up with less bids, fewer judicial controls in international law, and fewer rule of law internationally. The last point is a Crawford point, judicial cooperation and comity. For investment arbitration to survive, it needs to engage into a constructive dialogue with other international courts and tribunals, as well as the highest courts of the member states. Only then will we save our credibility and perhaps our survival. And by we, I mean the international investment arbitration community. Now let me turn to question 1b. You noted that Mr. Hupp this morning refused to answer your question as to the pro rata limitation of the claims in case you were to determine that only Vattenfall AB were a claimant, because he said they would be claiming for the entire investment and then, if pushed, found a way down to one of the subsidiary claims. Therefore, we look again at the corporate chain. Next slide. You will remember this, and I will have it in more detail later on. But what you see from here is that Vattenfall invested in HEW, which had accidentally still 3 nuclear power plants. If you were to compensate for E.ON shares, the OHGs taken together would lead to an increase of about 2 billion euros. The right side you see, and I will discuss it, that's for the portfolio effect, and I come back to that later in my closing. But look at it. If you do not limit, and if you do not properly account for own damage of C4 and C5, you risk giving money to E.ON as a German domestic investor. And I now come to question 2. This tribunal very rightly asked, how do we disentangle the consequences of Fukushima and other events that are none of Germany's making, not part of the measures, we're not responsible for it? You must distinguish. You must disentangle. You may not ignore, as claimants ignore it, because otherwise your award would burden Germany with with the effects of measures that we are not responsible for. And just to name a few, changes in the economy, such as the not anticipated decline of electricity prices, nothing to do with us. The consumption of electricity, climate change, saving of energy, even COVID. Because of COVID, less electricity has been consumed. All of that, if you take an ex ante view as claimants do it and you try not to disentangle it, you make Germany pay for all of these macroeconomic developments not related to the measures. And indeed, if you look at the but-for, what would be the but-for? Krümmel would be operating in this environment. It would have experienced COVID and the downturn of electricity consumption, the downturn of the electricity prices. But claimants are trying to shield their claims from all of that. You need, in order to disentangle, make sure that you do not do a but for Fukushima or a but for COVID valuation. You need to distinguish between the actual and but for scenarios with all available expertise to disentangle these effects. And you need to apply the valuation date consistently, because our claimants don't even stay on a pure ex ante. And again, a pure ex ante has a very significant risk of making respondent pay for general economic developments, none of which are measures. But they don't stop here. They even pick and choose. For example, just the slide 30, which I will talk about later, where they are trying to deduct at ex post utilization with ex post prices. Let me now move to the portfolio effect and its significance to respondent's case. And I'm going to show you paragraphs 168 and 170 from Tribunal's rejoinder on Q8, the very parts that Mr. Rühlander used in cross-examining Ms. Harden. And today, they didn't talk about it, but it was on their slide 11, that they said, well, it only is good for 1% differential in Dr. Cohen's low case projection. I will talk about these numbers in a moment. The portfolio effect is significant, very significant. And I want to clear up any misconception. And I was especially arising from a question from Judge Brower. There was a question, day 13, 3834, 3835, where Judge Brower asked, and I quote, is it the case that when you say Vattenfall, you're referring to every company that the parent company in Sweden has some interest in, either as a partially owned subsidiary or a wholly owned subsidiary? And later on, and they're in different countries, is that right? To which Dr. Cohen answered, well, here I'm just referring to the ones in Germany. Next slide, please. So here, just to be very clear, when we talk about a portfolio effect, we only talk about Vattenfall's German portfolio. Nothing in Sweden, nothing in the UK, Denmark, Finland, Poland, Netherlands, anywhere in the world, just Germany. And this slide is LH117, Vattenfall's 2010 annual report, page 31. It looks a bit like Asterix, and which is probably what helps you remember it. You've seen that slide, the next slide before, because we also discussed it with regarding to the picking and choosing and making respondent pay for E.ON's shares. On the right, the 95% are the other parts of HEW and other things Vattenfall invested in, but mainly HEW. 95% of Vattenfall's investment in Germany is non-nuclear. Tribunal question 8, paragraph 102, figure 2. And we've added the word German to make sure that nobody's confused. Indeed, you will recall that I said Vattenfall bought HEW despite its nuclear portfolio. I explained that in the 2016 hearing. Vattenfall was very clear and had concerns whether they should even invest in HEW because of Brunsbüttel und Krümmel. But here they're trying to pierce the corporate veil to claim not only for Krümmel and Brunsbüttel's own shares they have in them and in Brockdorf, but also for E.ON's shares. Indeed, claimants seek to redefine who the primary claimant is. I was very surprised because investment law, next slide, talks about investors, foreign investors. Here, Vattenfall asserts that the domestic entities in which a domestic company holds shares are their primary claimants. That's really putting investor arbitration on its head. And I checked. Professor Robert said that, not once, but twice. That's day 13, 3787, lines 10 to 16. And they said that in order to get out of the portfolio effect, which accounts for about 2 billion. Now let's stay with Vattenfall's idea for a second. Do Krümmel and Brunsbüttel, which are wholly transparent as OHGs, really have nothing else but nuclear power plants? Let's see. As I said, they're wholly transparent. Next slide. It's not just Vattenfall that has 95 non-nuclear portfolio in Germany. Look at the left side. The other shareholder, E.ON. E.ON that even tried to distance itself from its nuclear portfolio by calling E.ON Kernkraft Preußen Elektra because of the stigma attached of nuclear power that they didn't want to carry forward for the new image of E.ON.
Mr.
It
President,
has
I'm sorry to
non-nuclear.
interrupt Council for Germany. This is new. I hate to interrupt Council for Germany, but this is a completely new argument. It's not a summary of anything. These are new facts.
Overruled. Please continue, Dr. Conrad.
Thank you, Mr. President. And I think Mr. Happ's objections make it extremely clear why Vattenfall is so afraid of it. There is a portfolio effect for Vattenfall and for E.ON. They try to pierce the corporate veil to claim 2 billion for E.ON's shares. They try to define away Vattenfall's own portfolio effect. They try to define away E.ON's portfolio effect. And with that, I proceed to question 4, the electricity prices. Obviously, because of the brevity of time, I can only go big lines. But you will remember the slide from claimants opening with the electricity companies and ČEZ. But please, when you look at that slide, remember what I said. Temelin, the portfolio effect is not just limited to E.ON and Vattenfall. ČEZ also profited because of the energy exports into Germany. And that's day 113293, line 20. Claimants knew that the electricity prices and the effect of the measures on the electricity prices are a problem for them. And I show you again paragraphs 11 and 15 from Kaczmarek's third report, which show that they themselves argue that the prices as of 29 June were higher because of the measures. And that they are therefore trying to get it out. Now, claimants were asked by Professor Lowe, please, as a matter of causation, please disentangle it. What's caused by the measure, what is not? And Mr. Rülander's answer in the opening was, and that's transcript day 10, 2942, line 11 to 2944, line 12, answer was, it is impossible to isolate effects arising out of different matters. Later, when pressed, he referred to Mr. Kaczmarek. Let's go to Mr. Kaczmarek. Day 11, testimony 3164, line 17 to 3165, line 3, 3166, line 16 to 18. And I will read it in full. So our solution has always been, rather than to try to untangle it, let's move the date back and not have to deal with the entanglement. Or as you put it in line 21, quote, we don't have to get into the messiness by saying what percentage of the price increase relates to the measures, what percentage of the price increase relates to something else. And he says then in line 16, so again, our solution was, let's go back to March and not deal with the disentanglement, which we think is a very messy and difficult process. Then again, Kaczmarek testimony, day 11, 3314, line 17 to 3315, line 4. Quote, then I come back to my problem, and it's a problem. We've always tried to solve to do the right thing, which is we know the electricity prices in reality in August were higher. So we shouldn't take advantage of that in doing the valuation. Same issue in June. So we have to lower the electricity prices at that point in time. And that's underlined now here by us, but we didn't know how to do it. We didn't know what portion was related to the measures, taking 8 plants out, and what portion was related to other factors. Well, Dr. Cohn knew how to do it. You have that table in paragraph 14 of his third report, table 1. You see the prices are different, and they are based on the low case scenario, which is why the difference is smaller than if you apply Mr. Kaczmarek's future-based high price scenario. And not just Dr. Cohn knows how to do it. A whole industry makes a living of it. And I quote from Dr. Cohn, day 13, 3778, lines 7 to 19. Now, Mr. Kaczmarek has said it's difficult to isolate the impact or potential impact of the measures from all the other factors going on in the market. Well, it may be difficult, and underline this, but there's a whole industry out there of analysts and consultancies and firms that do this for a living, except that Mr. Kaczmarek is not part of this industry. But if you look at his studies, that's Dr. Cohn's fourth report, 318, figure 25. If you look at Kaczmarek's studies, which Dr. Cohn summarized, there is a price differential that you show. Let's look at who would have benefited, or who did benefit actually. And you know this slide. This is from Vattenfall's 2011 annual report, page 130, RC 218. In the opening, I highlighted nuclear and total and established that it's about 5% of Vattenfall's installed capacity. I now want you to look at a different figure, lignite, 7,123 in 2010 and 7,123 in 2011. That is about 47, nearly 50% of Vattenfall's installed capacity. It is about 10 times what nuclear is. We now look at the merit order, and to illustrate how the nearly 2 to 3 billion in Mr. Kaczmarek's futures prices correspond to the 193 million with Dr. Cohn's low prices. Now, the merit order curve looks, at least in this part, it doesn't go up indefinitely, very much like the exponential growth rates that we've seen in the news each evening. So look at the curves. In the second one, we have taken out the 8 nuclear plants, which shifts the merit order curve to the right. So the price making point is no longer within coal, but in gas. The price is higher. If you keep, and lignite is inside the production, so it's not price making in either scenario. So lignite is happily producing, no change in production, no change in fuel costs, because for lignite that doesn't apply, and it gets a higher price for the identical product. Now you have heard Mr. Rühlander talking about the taxes. Yeah, the taxes are actually pretty much the only thing that you need to take into account. He has made a big song and dance about the CO2 certificates, which is a red herring. If you go to NAV 241 figure 4, RC 148 figure 14, and RC 31, you can do the math. The increased output for CO2 by the coal and gas involvement accounts for, in the highest study that has the highest increase of output for CO2 released into the atmosphere, of 2.2% of the annual market of CO2 certificates in Europe. It's a drop in the ocean. It's not going to increase the prices. Indeed, had they tried to do a proper valuation of their alleged CO2 issue, which is none, they could have asked the future preferring Mr. Kaczmarek to look at the EUA futures. For example, in Dr. Cohen's first report at paragraph 69. Indeed, if you go to RC66, figure 3, and Dr. Cohen's third report, Appendix N, tab 1, you would even have seen that the CO2 certificates had fallen by June 2011. So the 2 to 3 billion before tax that Dr. Cohen calculated are solely just on the price differential benefiting Vattenfall's lignite production, 47% of its installed capacity. In reality, and if Vattenfall had done their calculation, the portfolio effect would be higher based on Kaczmarek's future prices, because they would have had the data also to account for their increased production in coal, in hard coal, and possibly gas, for which we didn't have the answer. We asked for it in document production. It's a matter of the burden of proof, and it's the burden of Vattenfall's proof. We've given you enough to see it's a huge problem of a huge magnitude that Vattenfall still doesn't want to address. I will now talk about the local. Yes, sir.
Let me ask a question. So
yes, sir.
If I look to your slide 30, it says impact of nuclear shutdown, low case. But so that is the low case of Dr. Cohen. But if we do not accept the low case, but an average case, how would the merit curve then look like?
The middle picture.
Exactly.
That's based on Mr. Kaczmarek's. We are just trying to reconcile for you, because it's a function of the in that part of the graph exponential curve for the normal merit curve, why the same change in capacity, taking out 8 nuclear power plants, has a differential of 2 to 3 billion in Mr. Kaczmarek's prices, and only a differential of about 200 million in Dr. Cohen's. And as I mentioned, there was a mention of that in Vattenfall's presentation, which they didn't go in. But here you see the simple mathematical explanation. It's how the price curve moves. An exponential curve, as we have now all know this year, moves very, very slowly in the beginning. It looks harmless. There's only a slight increase, but then it really gets going. And that's the effect of it.
Thank you.
Thank you. Thank you, basically. The low case production is my next topic. It reflects the rational assessment of a buyer of the market. You heard Vattenfall say everybody would buy nuclear power plants after Fukushima. Shares, EDF, wonderful market. That's not true. The low case projection reflects the risks of buying a nuclear power plant after Fukushima. It reflects the stigma of nuclear energy, the expectation or risk of macroeconomic developments, and the systematic risks of the utility market. Cohen testimony 3758 lines 4 to 21, 3764 line 7 to 3763 line 22, 3774 line 21 to 3776 line 5. Talking about the stigma again of nuclear energy, Vattenfall only call them PEL, Preußen Elektra. Preußen Elektra, an old name that E.ON hasn't used for 20 years. E.ON as an artificial word was chosen as the E.ON, the new age, the new beginning, 20 years ago. But today, apparently, nuclear power doesn't fit with that image, and they called their bad bank Preußen Elektra. Now, topic B, the consistent approach of the actual and but-for scenario on OEPV. You pressed Mr. Rühlander this morning to give you a figure for the OEPV, and he resisted. Then he brought up this famous slide 30, which was again trying to mislead you because he was using ex-post utilization to plug into an ex-ante model. Plus, what he didn't account for is the following. If you add the value of the OEPV to the value for the actual, you not only have an effect, deducting it and the DCF factor, you will see when you do it that Mr. Kaczmarek's tax adjustment suddenly gets smaller, and as more OEPV are modeled to have a value, disappears. Now, why is that? Vattenfall argues that this tribunal needs to increase its award to compensate Vattenfall for tax benefits it has already received from Germany because of the negative market value, they say, of Krümmel in the actual scenario. If you add the OEPV value to the price in the actual, it's no longer negative or only mildly negative. And in his own model, you see the tax effect shrinking. Moreover, and Mr. Rühlander was pressed by this tribunal as to, if you don't give us a figure, should we take Laura Hardin's? And I assume you will ask me the same figure. What if we don't take Laura Hardin's figures? Should we take Vattenfall's? Now, Mr. Rühlander's answer was the tribunal itself should adjust the figure, which would bring up a problem that I know members of this tribunal are confronted with in the challenge of the UCOS awards. How you get out of that conundrum, a very old answer, and obviously I haven't been able to offer this, but a very old answer comes to mind from the Horzov factory cases, which other people pronounce Chozo, even though it's incorrect. In that case and in the older cases, tribunals were number adverse. They didn't want to calculate, they didn't want to go through the expert opinions, which even at that time apparently were quite daunting. They appointed a tribunal expert. While very rarely utilized, this somehow slumbers still in the exit rules. Now, how do the offsets inflate damages? And I've already explained it by combining lower exposed prices of OEP.
Dr. Conrad, can I
Yes.
ask a question? So I submitted to Mr. Rühlander earlier today the question, well, what should we do? If we do not accept your position, that for the actuals, there is no value for the OEPV in June 2011. And what should we then, are we then forced to take the valuation, the value as advocated by Ms. Harden? And he said, no, as I understood him correctly, you may basically land in between, taking into account both positions, if we were to take that route. Is that also your position?
I know that if this tribunal were to take this position as arbitrators, Mr. President, that would contradict what you're arguing as counsel in The Hague.
Sorry, could you leave that out, please? Because I'm sitting as an arbitrator.
So apparently Judge Schwebel and the President Yves Fortier and Charles Poncet thought it is possible, and tribunals have the power then to reduce. The burden of proof in this specific case gives you a way out, because in the present case, Vattenfall have refused to give a number. So why the offsets are inflating damages? By combining lowercase exposed price projections, which were influenced by the macroeconomic demand of utilization, such as through energy efficiency, saving of energy, combining them with the exposed prices also influenced by macroeconomic factors, they drive down the number that they, the price which they offset, which still at these twice depressed price marker points is at 27.8. And then they implemented forgetting the tax adjustments. And what we've discussed in the actual scenario, attributing a zero value with exposed offsets, but in the but-for scenario, having the high future-based ex-ante values doesn't fit together. We've identified already 8 contradictions in our opening, and they stand. Also, a contradiction, you have heard the rational decisions of hypothetical buyers. Now, a rational hypothetical buyer allegedly would buy a whole power plant after Fukushima, and not just any power plant, Krümmel and Brunsbüttel, both of which are notorious in Germany, which everybody in the European power market knows. Conversely, they said, no market for the OEPV, although buying OEPV is a far less risky exercise than buying a whole nuclear power plant. And as I promised, I'm not going through all 8 contradictions, but the first one is the uncertainty. You have them accepting a utilization of Krümmel of 85% for the but-for, which is 18% higher than its historic average, but still too much uncertainty, Kaczmarek 4, paragraph 309 for the OEPV. As you will have taken away from my cross-examination of Mr. Kaczmarek, he has multiple utilizations. And let's start in the middle with the real historical utilization data until year-end 2010. Brokdorf is at 89% if you take that average. However, for the demand for OEPV, Kaczmarek takes 85, and his aim is to decrease the OEP value. Let's look at Krümmel. If you do the proper historical average, it's at 67. Mr. Kaczmarek's table gives you 77 because, quote unquote, purposefully excluded years. But for Krümmel going forward in the but-for, he takes 85 based on internal projections. Kaczmarek cross date 10, 3180, line 21 to 3248, line 20. Now, the purposefully excluded is a direct quote, and I'm giving you the source for it. Question. And can you see in this formula, the years in line 38 and 40 are again missing? Isn't that right? That was for Biblis too. He said, not missing. I would say 38 and 40, yeah, not missing, excluded for a valid purpose. Question, purposefully excluded? Answer, purposefully excluded, yes. Transcript 3196, line 20 to 3197, line 6. And we've given you also a snippet from the Excel sheet on the slide. Krömel, and I'm sure you now know this chart by heart. It's originally from the Grau fourth report, page 161, appendix 11.2. And if I was to give you a line at 85, you would see that Krömel very, very rarely exceeded the 85 in reality, whereas in reality, it very often was much lower. And we have included as small pictures from the famous fires or from the burst valves, where Dr. Klosters had to really insist that they check when then they found the third little picture that you see. And all of that is in more detail in our 2016 opening and closing. But we have, during the course of this week, not just kept it at 8 contradictions, we found a 9th. In the actual scenario, claimant opening statement, day 9, 2988, lines 14 to 19, and I quote, even if you could project with certainty that a transaction for a particular number of volumes would take place at a particular point in time, then there's the problem of determining a price 8 to 11 years in advance. And when you asked Mr. Rühlander just during the closing, he referred to Mr. Kaczmarek's quote unquote rules. Whereas in the but for, he has no problem. He takes futures, expands them 20 years into the future, while there are no 20-year futures, because even the short and midterm futures are illiquid after 24 to 36 months. Now, international law is a law that deals with long stretches of time. We're kind of the historians of all legal professions. Investment law is actually one of the less long-term kids of international law. Think of the boundary disputes where you go back to the Middle Ages to see who had what grazing rights in Africa, where no written tradition exists. In investment law, we have written records. So that makes us young. And still in that, we're dealing with long-term investments. Think of oil concessions, oil fields, power plants. 30, 40 years is not a rare thing. So if Mr. Kaczmarek's rules, quote unquote, don't permit him to value a price 8 to 11 years in advance, that is a contradiction. I will now move to my next topic, C, on the model flexibility, on Mr. Kaczmarek's toggles. There are no toggles in Mr. Kaczmarek's model to allow you to reflect for a 2021 Brokdorf shutdown instead of 2019. And we all know there's no evidence it would shut down in 2019. No toggle relating to the value of OEPV. No toggle OPEX and CAPEX. No toggle on decommissioning, electricity prices, tax adjustments, CAPEX prorations, salvage parts. But we have the defunct toggle, tax adjustments, meaning especially the nuclear fuel tax. We have the defunct Article 21 ECT toggle, which Mr. Kaczmarek represented in transcript 3290, lines 6 to 17, and I quote, the toggle has been defunct since 2017. I think no, he's staying. When answering a question of the president. There was also a question, what is meant by factual matrix of the payments of the nuclear fuel tax? And you will remember that slide from the opening. Now, it is relevant for modeling if you put yourselves in the shoes of 2011, whether that's in March 2011 or in June 2011. We have claimant's explicit admission in the reply post-hearing brief at paragraph 691, and I quote, Germany suggests that Mr. Kaczmarek should model hypothetical NFT payments and repayments based on a specific chain of events which transpired in 2017, i.e. the Bundesverfassungsgericht, and which was, underlined, not knowable as of Mr. Kaczmarek's valuation date. This is not the proper approach for ex-ante valuation. This means that both for the but-for and the actual, you have to model the payments for NFT. In the but-for, claim Krümmel would have paid NFT until 2016, because as the claimants say, it was not foreseeable that the Bundesverfassungsgericht would hold the tax invalid. In the actual scenario, Krümmel does not pay NFT because it's not operating, but it is selling its OEPV, which we know have a value, only after the NFT has ended. That's what needs to be treated as part of the factual matrix. It's a consequence of ex ante information, plus also a consequence, and sits more easily with Article 21 of the ECT. I will now move to topic D, adequate maintenance, Grauf and Grötzinger versus Kleen and Blesig. Transcript 3702, line 10 to 15. You remember, no questions to Mr. Grötzinger. During our entire hearing, claimants no longer raised any issues on the Bund-Länder-Liste, which Dr. Grötzinger rebutted. Let's turn to Kleen. That's transcript 3104, line 18 to 3105, line 4, 3100, line 19 to 3101, line 8. There was SAP data available. He did not, and claimants did not submit them. Instead, they doing 2014 OPEX ongoing maintenance expenses and calculations on the basis of lump sums. And during cross-examination, Mr. Kleen explained he was working on a 10-year average of maintenance cost, exempting the years where there were the problems, the fires, the shutdowns. So basically, he's extrapolating from maintenance costs, which apparently were not sufficient to avoid the problems that Krümmel was experiencing. Dr. Grauf's costs are conservative. You remember that slide from the opening. He only added 344 million to Vattenfall's cost calculations instead of E.ON's 3.1 billion. Dr. Grauf has, as you've heard during his testimony, 50 years of experience in more than 15 countries. He's a member of the Reactor Safety Commission since '98. He helped draft the regulations that we are applying. And he managed Neckar-Westheim 2, the plant with the 91% lifetime utilization. So we put it, he actually knows what he's doing. But Vattenfall says the commissioning costs for Brokdorf are unreliable. That's Blesig testimony, redirect by Mr. Happ, 3566 lines 2 to 8. And in total, or all in all, Brokdorf was not examined in such detail by us the same way as we did for Krümmel. End of quote. But Vattenfall, that apparently seems to be challenging the Brokdorf calculations, wants 346 million for damages for Brokdorf for the LTE scenario. I would say that's a 10th contradiction. Topic D, earthquake safety. You saw the slide Mr. Happ showed about the extent of the Grauf issue. What he didn't mention is the seismics, the safety of the plants. Indeed, were trying because apparently the 2016 evidence was not enough for them with Mr. Neumann, who violated PO1, not disclosing the relationships between his Framatome and claimants, apparently because the lawyers told him he only had to focus on himself, other than using the normal disclosure concept that we know, that we have to disclose everything as arbitrator, what happens to our law firm, that we are counsel in a case, opposing counsel, issue conflicts, etc. But apparently for Neumann, the rules are different. Now he said that the earthquake in northern Germany was unlikely and therefore nobody needed to account for it. And I show you a map of northern Germany. And what you will see is the Krümmel plant is the only one in northern Germany that is not for which Mr. Neumann argues a level 3 is not necessary. It is only less than 100 kilometers from Burgdorf, which is level 3 compliant. There's no plant that doesn't comply. On decommissioning, you remember the slide I showed Professor Tomauske, and that only Vattenfall needs as long. That's his table 1 in paragraph 72 in his question 8 report. He then tried to argue the whole duration after the post-operational phase. Now that is misleading. One, because the first years are the most expensive ones, the costs peter out at the end, and also because of the time value of money. You also will recall Professor Tomauske made a big song and dance about unavailability of castor containers for loading. Vattenfall's own failure to order casks and to reapply for a new license for those casks is what caused this. And Tomauske, as you know, had been working for the authority that were giving the licenses. Still, he said, and that's lines 3450, line 18, 3451 to 11, that is a hypothetical question which I couldn't really answer. Then also you will recall the lack of clarity about the input for the NIS data and the fact that Vattenfall was the last one to apply for decommissioning for all of the 8 plants shut down in 2011. But he did answer one question. You will recall the Hackel issue at the 2016 hearing. The man who was hospitalized allegedly, but wasn't, and then ready to testify. After 3 years of complete silence, we had an excuse from claimants in February 2020. That's claimants' letter of 5 February at paragraph 2.4. They finally came up with an excuse why there was this quote unquote simple communication error. And they said that Mr. Hackel had on the Friday evening between in contact with a lawyer at Luther who's not part of, underline, team handling the present arbitration, but works in a different practice group at a different office. And I asked Professor Tomauske, with whom did he have contact for the preparation of the 2016 hearing? And I asked, question from Luther from the Düsseldorf office. Answer from Luther from the Düsseldorf office during the first preparation of first hearing. I have had contact. I remember at least one guy. That was Mr. Leiniger. And I couldn't help myself but said, indeed. And this is a transcript 3482, lines 5 to 9, and 3483, lines 1 to 7. Question 5. If you were to accept they have value, and if you attribute to them an ex ante value as to the value of the OEPV, and if you do use the demand for OEPV on an ex ante value, as Ms. Harden's models, and by the way, both experts agree, also Mr. Kaczmarek's first report models a demand of about 94 terawatt. And if you then apply the price that Ms. Harden calculated at 30.78 per megawatt hour, then the offsets become irrelevant. And also that's the proper way of putting them in, because they also show then the effects of the taxes. And this is in the OEPV only scenario. For the other scenarios, we will have to get back to you in the post-hearing submission. Question 6. I explained before I started, we had only the book values. We don't have the contracts from Vattenfall. We don't have an inventory. Had we had that, we would have tried to give you a more detailed calculation, but claimants never disclosed them. Now, uranium is directly used to the utilization of power plants. The fact that there are no 69 line over speaks for itself, because all of them have been retired, including the one that never went on the grid, but used as a filming location for nuclear disasters in Austria. Also, as a part of the inventory on the technical stuff, I would have misgivings buying spare parts from Krümmel. Think of the transformers. Question 7. Now, there is obviously a typo in paragraph 372 on our Q8 rejoinder, and we believe that the two figures have to be inverted. But on details, I have to do the Vattenfall this time and say we get back to you in post-hearing submissions. And let me now sum it up. Claimants are still refusing to address question 8 with June valuation. They're now trying to put investment law on its head by using domestic entities as their primary claimants. They even tell you that even if you only have the foreigners as claimants, you have to pay to the domestic entity. I'm sorry, I've never seen that. The claimants in investment treaty arbitration are foreigners. The award, the prayer of relief, is pay to claimant Chevron, Exxon, the Unglaubes, although they're natural persons. It's paid to the foreign investor. Now, saying that even if you have the foreign investor as a claimant, you pay to the domestic entity, I don't think so. I mean, if Vattenfall miscouched their prayer for relief, that is not our problem. Moreover, they're trying to do that to assert, the domestic entities are the primary claimants, to ignore the portfolio effect on their 95 conventional German portfolio in which they invested and with which they were at the same time buying the nuclear power plants, because they had been part of HIV, and which at the time they had misgivings whether they should invest in HIV because it also had nuclear power. They're trying to claim for E.ON shares, but ignoring the portfolio effect on E.ON. They're still trying to allocate value to the OEPV, which even at lower exposed utilization and lower exposed prices, both of which have nothing to do with Germany's measures, but were a function of the general economic development and other factors. Even at lower exposed prices, lower exposed consumption, almost $1 billion has been recovered, but they're still trying not to account for the value. They're ignoring the consequences of Fukushima, their own operating history with the fires, and generally they're trying to ignore the stigma of nuclear power after Fukushima. Thank you very much.
Thank you, Dr. Conrad. I look to my co-arbitrators. Judge Bauer, any questions?
Not for me, thank you.
Professor Low, any questions?
Well, and there are 2 or 3 points on which claimants may want to come back, but one particular that I wanted to raise was the question whether Dr. Conrad had raised with claimants the question of the appointment of a tribunal expert, or if that was something that was just introduced now.
It was something I said in response to your questions to claimants. this is obviously in the powers of the tribunal to decide. If you want an agreement by the parties whether to appoint or not appoint a tribunal expert, I would have to take instructions. But as I said, it's a power that still exists in the exit rules as of now.
Yeah. So not yet raised between the parties. No. Thanks, that's all.
Okay, Professor Aubert, you would like to respond to the matter of the expert as suggested by respondent in response to a tribunal question. Sorry, Professor Aubert, you are on mute.
Sorry, I'm not sure that was actually a suggestion, but more than like an idea. But either way, we would need to take instructions to talk to our client about that.
The point is this: it was in a discrete point, which also I put to Mr. Reilander, which was if you one side does not put any value to the OPVs in the actual, and that's your side, Professor Aubert, to the OPVs in the actual scenario, whereas respondent puts a high value, if I may call it a relatively high value, to the OPV in the actual scenario. And my question then was, well, what is maybe as tribunal come to a conclusion, as I understand that was a suggestion by Mr. Reilander, you may land in between if you do not accept the no value position. And now I understand that Dr. Conrad says you may not do that because you may not determine either, you have to choose either respondent's position or claimant's position in that respect. That's how in that context it arose. Do I summarize correctly, Dr. Conrad?
I believe so.
If I may ask Dr. Conrad, you were citing Judge Schwebel in the E. Fortier to what effect then?
I was trying to make the point without exposing the president of the tribunal. So in the UCOS case, the tribunal was not convinced by the valuation of Mr. Kaczmarek, same Kaczmarek we have here, and took it upon themselves to correct the numbers put forward by the UCOS claimants. Russia had not submitted their own valuation, if I recall. Now, what is different in our case is that both OEPV and portfolio effect are things within the burden of proof of claimants. So if you follow the rules of burden of proof, you don't need a tribunal expert. You basically say, Vattenfall did not assign value. You dismiss the claims. Alternatively, you can take our numbers.
Thank you.
Well, Mr. Chairman, if I
Exactly,
may.
I was about to give the floor to you because I first summarized, see whether I summarized correctly respondent's position, and I would like to give the floor to you, claimants, Professor Aubert.
Well, I think as Mr. Reilander explained before, I mean, this is not a unique situation. It happens in many cases where a tribunal has to determine damages. If one party is asking for 10 and the other concedes only 5, it's for the tribunal to figure out what the right number is. And it's based on, you could call it burden of proof, or it's based on, has to be based on the arguments and facts and evidence before the tribunal. So there is no, binary, approach, in my view, in our view. If the tribunal feels it needs an expert to assist it, I mean, that's another matter. You would need to go back to the parties to ask for our views and maybe permission to do that. But the starting point is this: it's now before you. You have the information the parties have provided you, and you have to make up your mind based on that information.
The point is this: so going back to the parties is to avoid surprise decisions. But that's one thing. But the other thing is if you have been arguing various positions, and within the limits of those positions, the question is the tribunal has a margin of maneuver to determine, for example, in this case, what is if there is any value to be attributed to the OPVs in the actual scenario.
Yes, the short answer is yes.
Okay. And Dr. Conrad, is that also your position?
Sorry, I just lost the transcript for a second. I think you've summarized it correctly, but I'm not saying that we agree to a reduction of Mr. Harden's prices, given that we learn from the best in the question of set-aside applications.
Okay, no, thank you, because that clarifies the situation. We want to avoid, obviously, as a tribunal, that we come in the situation as the WWM tribunal, just last week, which was sent back because for a surprise decision. At least that's what the High Court in London said. But I don't take position there, but we try to avoid getting in those situations.
I would disagree. I think what the High Court said was they were confronted with claimants who, like Vattenfall, took an all or nothing position, and the tribunal was reluctant to give nothing and adapted their tenor to it, going on a net, basically on sunk investments. You could read the High Court to say that if you have an all or nothing claimant and they fail, they should get nothing.
Right, but let's stop there because that's more a discussion for an OGB forum or an ECA Congress.
Yes.
If I may say so. Simply where we are. So then the next step is on the what we have still to do today is the toggle, the model questions. Professor Aubert, Dr. Rapp, have you how many minutes do you need for a presentation on that point?
I think Mr. Rylander will need like 1 minute.
1 minute?
To make that explanation, yes.
Or that we can do it. But Dr. Conrad, are you in a position to address the questions on model?
No, we are not.
Right. But then, Mr. Rylander, please wait 1 second because I have to pull out a copy. Yeah, I have it. Okay, please go proceed.
Thank you. It may be 2 minutes.
All right. Okay.
Yeah.
I take the letter simply as yes, no. As we have heard last week, everybody saying to the experts and witnesses, please yes, no. May I say that to you as well, or you want to have an explanation? Give an explanation.
I can answer as some experts do. I'll give you a yes and no, and then I'll expand a little bit.
Okay.
So, I mean, just to make sure that we're on the same page about what you're asking here. As we understand it, the tribunal has identified 4 different scenarios, depending on whether March or June data is used and whether the revocation of the NPV is deemed to be a breach or not. Yeah. I think I've understood that correctly. Yeah. And then the first point from our side is that under all of these 4, under respective items A, you have found the right models from Mr. Kaczmarek. So with respect to A, our answer is yes, those are the ones you should use.
Okay, good.
Then when it comes to the B's and C's, if I may call them, those, however, cannot be used as a basis for any adjustment.
Okay, but Mr. Reinhold, I have to point out to you there's a distinction in the wording between A and B and C. A has the and B has the or between B and C. Yep. Okay.
Yeah, and then I can clarify that for B and C, it's neither.
Neither. Okay.
Yeah, and I think we can come back in more detail in our posterior submission, but just generally, of course, our main problem is with the fact that Ms. Harden's calculations, in our view, are not reliable. I'm not going to go back and argue about that here. But then there's also some logical and other reasons why Ms. Harden's tables here cannot be used in the way that the question suggests. But I think it's easier if we sort of structure that in writing.
Thank you.
So that was it. Perhaps 3 minutes.
Dr. Conrad, still no reaction on this? On the models?
We can't, but what I can say is that we do not find Mr. Kaczmarek's calculation convincing at all.
Okay, right. Thank you. So then that concludes this one. I look to my co-operators. Any further point question you would like to ask? Because we come now to the closure of the hearing. I have a couple of points of procedure to mention, but are there any other questions you would like to ask?
Not for me.
Dr. Bauer, Professor Lowe?
Not from me, thank you.
All right, okay, so then the tribunal has deliberated on the question of the post-hearing submissions, the dates. We will determine that, or we actually have determined that the post-hearing submissions are simultaneously be submitted on 8 April 2021, and the reply post-hearing submissions on 23 April 2001. Then we have another question is the still outstanding. As Aubert or Dr. Happ, have you been able to get instructions on the streaming as proposed by the respondent, that we maintain the opening and closing statements for more than 1 week, like they've done for the hearing in 2016?
We have, Mr. President. Our client would agree to keep the complete recording.
Complete recording, including also the witness test, the expert testimony, witness testimony.
I look again to my client. Yes. Yeah, including the witness testimony.
That's more than we asked for. Let's see, Dr. Conrad, does the respondent also agree in the full transparency mode?
I have to seek instruction, but I can guess what it is. So I'm very happy with claimant's agreement to implement more transparency. But we will confirm.
Right. Then I ask first the claimants, Professor Aubert or Dr. Happ, is there any further question of procedure or administrative nature you would like to raise?
Not from our side, but I'm told though that the video from Wednesday's hearing has not been published yet for some reason. I don't know if that's still the case, but I think both parties have agreed to the publication of that one. So it's just
where are we there?
Yes, sorry. Yes, the video will be published today. It was available yesterday, but a bit late and Thanksgiving celebration, and we apologize.
It landed under Turkey, I guess. Okay. Right, so it will be published.
In that case, I don't think there are any further issues from the claimant side, Mr. Chairman.
Dr. Conrad, for the respondent, any procedural administrative matter or the matter?
Thanks to David. Thanks to David for killing his Thanksgiving. Thanks for everybody who had to get up at an unseasonable hour. And thanks also to the logistics and those people helping with the logistics, including in people's respective homes, which have had to bear the brunt of an exit hearing at home, which hopefully when COVID is over, will be again deferred to hotels, so our families don't have to suffer through us in hearing mode, which while we enjoy it tremendously, is something our families don't enjoy.
Okay, thank you, Dr.
Mr. Chairman, for once, we're in full agreement with the respondent.
Thank you. So that also echoes what the tribunal wanted to say. We very much thank David for the transcript and seeming hours, civilized hours almost, if I may call it that way. We thank also TJ and Steve for FTI for the wonderful cooperation and also support. Thank the interpreters, as we did already before. We would like to thank Exit for making this all happen in this virtual era where we are living. We in particular would like to thank the Secretary of the Tribunal, Gara, and our assistant, Emily. And above all, of course, we would like to thank, on behalf of the Tribunal, counsel on both sides for the very professional presentations. It was very helpful to us. And I think then we can now come to a closure of the hearing. We will do our best to have the award issued as soon as possible after we have received the reply posting submissions. There's one little item outstanding there. Before I really close, the cost submissions.
Now, Mr. President, this was decided in PO 44. It's 2 weeks after the reply submissions.
Exactly. So, but we have the date, no?
Well, 2 weeks after the 23rd.
I simply want to have dates.
I believe that's the 7th of May.
Okay. All right, 7th of May. Then we soon thereafter we will have you have the award. All right. Have all going and very peaceful and enjoyable weekend, and take some rest. Thank you.
Thank you.
Thank you very much. Thanks. Bye bye.
Thanks.
Thank you very much.
Thank you very much. Bye bye.